listeners out there. My name is Imran Dabo from the Gambia Bar Association, and today we will be discussing the transitional justice process. Of course, we are all familiar that the TRRC conducted its work from 2018 to 2021, and from there on, we are now in the implementation phase of the recommendations of that Commission's report. Part of that, we will be discussing today the accountability processes that that have been recommended and that have been initiated to facilitate this process. With me, colleagues from civil society and the Ministry of Justice, I will just allow them to introduce themselves before we get into the discussions.
Assalamu alaikum. Greetings to all the viewers out there. My name is Safia Twinyan. I work at the post-TRRC unit. That's the unit created to coordinate the implementation of the TRRC recommendations. As indicated by Imran, we're here today to talk about the transitional justice process, but particularly on justice and accountability. So we'll be taking you through the steps that the government has taken so far to achieve the targets.
And let's just welcome God in our presence. Thank you. Amen. Amen. My name is Amanda Cole, and today I have the honor to host this event. And I just want to take this moment to recognize great people in our midst. And first on our list, I want to acknowledge Mr. Hussein Tomasi, Solicitor General and Legal Secretary. Good morning, sir. And I also want to welcome Madam Ida Person, Special Advisor on Transitional Justice. Good morning. And I also want to acknowledge Mr. Didier, the Ictj Head of Programs, Gambia. Good morning, sir. And to all others, dignitaries that are here, I want to say good morning and thank you for coming for this important event. And I also want to acknowledge Madam Priscilla Yagum Sise. Good morning, Madam, and thank you for coming. And to all the press, thank you very much for attending this great occasion to cover it. And I want to say merci beaucoup. All right, so we start up the event, and I want to take this opportunity to have Madam Priscilla Yagum Sise giving a welcome remarks on behalf of AVLO. Thank you very much. Put your hands together for her.
His Excellency, Mr. Hussein Tomasi, Solicitor General, Mr. Didier Berry, Ictj Head of Programs, Ms. Ida Person, Special Advisor to the Minister of Justice, ladies and gentlemen, all protocols observed, good morning and welcome to this event. I'm honored to be giving the statement on criminal accountability in transitional justice. As we must be aware, transitional justice refers to a set of judicial and non-judicial measures which are implemented by societies that are coming out of a period of dictatorship or following periods of dictatorship following authoritarian or during an era of conflict. So a critical component of transitional justice is criminal accountability, which seeks to ensure that those who bear the greatest responsibility for acts of human rights violations that had been committed are held accountable. And those violations amount to separate different types, including crimes against humanity, genocide, um, and war crimes in some instances. In the context, it also seeks to ensure that society regains trust in institutional processes, and that victims, they also get the redress and the healing that they need to enable them to rebuild their lives. So investigations and prosecuting international crimes, crimes against humanity, as we've talked about, serves multiple purposes within TJ frameworks. It reinforces the rule of law by demonstrating that no individual, regardless of their position, is above the law, and that high-profile individuals who bear the greatest responsibility should be held accountable. Prosecutions, criminal accountability, investigations also are often key demands from victims who seek acknowledgement of their suffering and accountability from those who are responsible for the violations that they have had to endure. Despite the importance of criminal accountability, there remains a number of challenges, and some of them are significant. In some instances, the large-scale nature of many international crimes often leads to an impunity gap. And so this needs to be considered at all levels, because not all perpetrators can be prosecuted for all crimes. So there's definitely a need to look at how resources which are available would be used through different traditional legal systems. The impunity gap can be exacerbated in post-conflict societies where political will may be lacking and where legal infrastructures may be severely weakened or non-functional. In such contexts, effective prosecution strategies is typically focused on high-ranking officials, the planners and the organizers, rather than low-level perpetrators. Notwithstanding, measures should be in place in order to ensure that identified perpetrators at different levels are held accountable for their part in committing human rights violations in the country. So whilst domestic prosecutions are generally more impactful as they occur within the society that is affected by the crimes, they also face numerous challenges and obstacles. Societies that are emerging from conflict may struggle with political will, political instability, or lack of capacity in order to conduct fair trials. In contrast, international mechanisms, such as, for example, the ICC, can provide an alternative avenue for accountability when domestic systems fail. For example, as some of us might know, the ICC was established in 2002, and they intervene only when national courts are unwilling and unable to prosecute. So in this sense, we look at complementary approaches to justice. This effectively closes the impunity gap and ensure that criminal prosecution should be part of a broader strategy that includes reparations programs, institutional reforms, and truth-seeking initiatives. With those initiatives, we can also seek to address the needs of the victims whilst promoting societal reconciliation and also preventing further atrocities. So, in conclusion, whilst criminal accountability is a cornerstone of transitional justice, it definitely seeks to play a vital role in restoring dignity to victims and rebuilding trust within communities. As such, by addressing past injustices through investigations and fair trials, whether domestically or internationally, societies can pave the way for lasting peace and stability. And on that note, we hope that the mechanisms that we will be discussing today, they would contribute to ensuring that we do get criminal accountability for human rights violations that had taken place in the Gambia. Thank you.
Thank you very much, Madam Priscilla, for that wonderful welcome remarks. Next on the agenda, we have a statement, and that will be done by Mr. Didier, the Ictj head of programs, the Gambia. Thank you.
Thank you, Amanda. Honorable Solicitor General Mr. Tomasi, distinguished representatives of the United Nations and members of the diplomatic corps, esteemed members of the post-TRRC unit, esteemed representatives of the victims and AVLO, respected panelists and stakeholders, ladies and gentlemen, all protocols observed. It is a great honor to stand before you today as we gather to discuss one of the most critical issues the Gambia in its post-dictatorship recovery. That is the advancing of accountability for crimes committed under the regime of former President Yahya Jammeh between 1994 to 2017. At this moment of significant transition, the Gambia stands at the crossroads of justice and reconciliation. The establishment of a special accountability mechanisms and the intended creation of an internationalized hybrid court represent essential steps towards achieving the rights of victims to justice and accountability. These mechanisms are not only vital for the victims of the atrocities committed during the Jammeh era, but they are also for reinforcing the rule of law, fostering national healing, and ensuring that future generations can live in a society founded on respect for human rights, democracy, and justice. This forum today will provide a platform for important dialogue. It aims to discuss the government efforts and initiatives to advance accountability in the post-TRRC context. We intend to do that on a regular basis to update stakeholders and the public on the progress on implementing the accountability-related recommendations of the TRRC, and it will serve as a platform to discuss how we, as stakeholders, we can collaborate and contribute to advancing this critical agenda. Ladies and gentlemen, on behalf of the International Center for Transitional Justice, Ictj, I would like to extend our deepest appreciation to all of you for being here and for your ongoing commitment to ensuring that justice, truth, and reparations are integral to the healing process of this nation. I would like to take this opportunity to extend a special word of gratitude to our partners, the Office of Global Criminal Justice, whose generous financial support has made this event possible. Their commitment to supporting the Gambia's transitional justice process is commendable, and we are grateful for their ongoing partnership in this vital work. I would also like to express our sincere thanks to the government of the Gambia, and in particular to the Ministry of Justice, through the post-TRRC unit, for its constant leadership and collaboration, and in advancing the national transitional justice agenda. We look forward to working together to ensure that the Gambia can fulfill its obligations to victims and to the future generations. In closing, I want to reiterate that this forum is not just an opportunity to reflect on what has been accomplished, but also to actively engage in shaping the future of the Gambia. As we move forward, let us be guided by our shared commitment to justice, human rights, and accountability, knowing that our collective efforts today will have a lasting impact on the Gambia's future. Thank you for your attention, and thank you for your participation.
Thank you, Mr. Didier. And at this point in time, we would love to have an opening statement by His Excellency Mr. Hussein Thompson, the Solicitor General and Legal Secretary. Welcome, sir. Thank you.
Thank you very much, Madam Amanda Cole. I believe I pronounce your name very well. And I like the name Amanda. Anyway. Good morning, everyone. Let me first recognize the members of the High Table, Mr. Didier Berry, the head of Ictj in the Gambia, Madam Ida Person, the Special Advisor to the Honorable Attorney General and Minister of Justice, Madam Priscilla Yagu-Williams, the head of WAVE. And in the same vein, I want to recognize members of the Diplomatic Corps, in particular the presence of Madam Enya Braun from the EU. I also want to recognize the presence of the President of the Gambia Bar Association, Madam Nene Cham, who is in our midst this morning, and as well as members of the security services, representative of the IGP, and the Gambia prisons. Esteemed members of civil society organizations, victim rights organizations, all here present, actually very eminent personalities we have in this room, that if I want to name all, we would be here probably the whole day. But I see Mr. Imran Dabo, and the head of ANECED, and as well as Madam Jame, and quite a lot. Also, if I may recognize the community and religious leaders that we have in our midst, elders and victims who have been following this process keenly with us since the inception of the Transitional Justice Program. Having said that, Excellencies, ladies and gentlemen, it is with great pride, actually hope and optimism, that we convene today for this important stakeholder forum on the special accountability mechanism. As we gather here, we acknowledge the significant strides the Gambia has made in addressing the legacies of past injustices and the ongoing commitment to promoting accountability for human rights violations. Reflecting on the progress in the Gambia's transitional justice journey, it is crucial to recognize the courage and resilience of victims who, after years of human rights violations in this country, bravely shared their stories during a truth-seeking process which has brought us to this very moment. And it is their trust in this process, their confidence in this process, their utmost belief in this process that we are called to honor. In response to the TRRC's recommendations, the government in May 2022 issued a white paper that agreed to implement 263 out of the 265 of the TRRC's recommendations. Sections 19 and 20 of the white paper calls for the establishment of a special accountability mechanism, which includes the Special Prosecutor's Office, the Special Criminal Division of the High Court, and the Special Tribunal, to investigate and adjudicate the human rights violations recommended by the TRRC for prosecutions. This commitment clearly demonstrates the government's dedication to honoring the voices of victims and affected communities while addressing human rights violations that were committed in Gambia and on Gambian soil. In this same vein, the government has launched an implementation plan that now serves as a roadmap for securing justice and promoting reconciliation. Ladies and gentlemen, in addition to advancing the special accountability mechanism through the passage of the Special Accountability Bill this year, which is now an act, we have witnessed the passage of the Special Prosecutor's Office Act by the National Assembly also. These steps have led to the establishment of an independent selection panel tasked with the identification and recommendation of the most qualified candidates for the Special Prosecutor's Office. This office will oversee and investigate prosecutorial functions, as well as play a crucial role in restoring public trust in the transitional justice process. Moreover, the government this year proposed a partnership with the ECOWAS Commission to establish a special tribunal, a significant step towards accountability. In February 2024, a joint technical committee was formed to develop the necessary statute and draft decision for the tribunal. As part of this proactive approach, the committee scheduled technical meetings with key officials to finalize the messaging around the tribunal's establishment. Furthermore, the government is set to present a memorandum on the special tribunal at the upcoming ECOWAS Heads of State Summit in December this year. Actually, that's just next month. So we are hoping to table this matter before the ECOWAS Heads of State Summit that is coming up next month, most likely in Abuja. Today, we are here not only to share updates on our progress, but also to engage in meaningful dialogue. You, the victims, partners, civil society organizations and representatives, as well as other stakeholders. This process that we have embarked upon in pursuit of justice and accountability is actually a very long and often a difficult one. Notwithstanding, Excellencies, ladies and gentlemen, your insights and perspectives will always be invaluable as we work together to foster a transparent, inclusive, and participatory process that promotes public trust in our accountability efforts as a country. The change we face are significant. The challenges, rather, that we face are significant, but so too are the opportunities for collaboration and growth. By coming together in this forum, we can address misconceptions, enhance understanding, and strengthen support for our collective goals. I encourage open discussions as your voices are essential in shaping the future of transitional justice in our country. Excellencies, distinguished ladies and gentlemen, I urge all stakeholders here present to recognize the value of this forum and the overall objectives of the Special Accountability Mechanism, and to work together to ensure that the voices of those affected by the profound human rights violations and abuses that occurred in the Gambia between July 1994 and January 2017 are heard. Together, we have a collective commitment to strengthen our nation's pursuit of justice and to uphold the rights and dignity of all as we enforce accountability and ensure that impunity has no place in the Gambia. On this note, Excellencies, distinguished ladies and gentlemen, it's my pleasure to declare this workshop open and to wish you all a very productive session. I thank you for your kind attention.
Thank you very much, His Excellency Mr. Hussein Tamsin. Thank you very much. Okay, so on our agenda, we have presentation, this will be done by Madam Mariam Singate from MOJ, and also Madam Priscilla Yagum Sise from WAVE. And this part is the most important, and then after that, we'll be having a group photo before the panel discussion. So I would love to welcome Madam Mariam Singate. Is she? Okay. Put your hands together as she comes, and alongside Madam Priscilla Yagum Sise to do this presentation on the Special Accountability Mechanism. Thank you very much. Thank you. Yes, sir. Thank you very much. Sorry, do you want to sit there and do it, or do you want to come and wish you? Okay, that's fine. All right. So media team, please, can you just switch over? Thank you. Can she start first?
I can barely. Is this movable so I can see myself? Yeah. Maybe I can get a microphone. Is it possible? Does it move?
No.
Maybe
Take
I can
Priscilla.
use this one. Thank you, Priscilla. So I think we're finally set. It always feels like an intrusion with all the mics, but good morning, everyone. I've been asked by Ms. Cisse and Ms. Singate to give just a general overview of the SAM. Considering what we've heard from the Solicitor General's remarks, it won't be a very extensive one because he's already introduced a bit the SAM. But to afford opportunity, we realize in the program for a bit more question and answer so that we can really clarify what the special accountability mechanism is. So please, if you are having questions as we are discussing the issue, do note them down, and then we can have a question and answer immediately thereafter. I hope you're all comfortable. I tend to find this room to be very cold, freezing in fact. It is freezing. I have worn a winter jacket in this office before. So I think that sets the tone, which is that this is a discussion. It's a dialogue. Now we know that the statute for the Special Tribunal is before ECOWAS. We know that the Special Prosecutors Act has passed its law. We know that the Special Accountability Mechanism Act has passed its law. And that's true. We have perhaps very little room to change those texts. But in terms of implementation, there's all the room in the world for us to dialogue and see how best to manage all expectations. The Special Accountability Mechanism has been introduced in the Gambia in April 2024. The government of the Gambia thanks all the partners that worked on developing this law, particularly the Gambia Bar Association. So the Gambia Bar Association, if I could just take a moment to say, is one of those organizations that started thinking about what accountability would look like at the end of the TRC process. And in 2019 mobilized not only the government, but other partners, Ictj, Human Rights Watch, and others, to start discussing what would an accountability mechanism look like for the Gambia. And why are we having those discussions? Well, it became very apparent during the hearings that perhaps some of the crimes we're talking about have not been captured in our law books. Believe it or not, torture, for example, the issue of enforced disappearance. And when we consider incidents such as the witch hunts in 2009, perhaps even crimes against humanity. Now, these are all crimes that in the Gambia were not law, and in some instances continue not to be law. But there's another aspect to it as well, which is a policy decision. We're in a transitional justice phase, right, where victims' voices and the population's voices are at the fore. It cannot be the typical court procedure where there's very little room for victims to participate or for the public to even be in the courtroom. So we had to create a system that would allow for some kind of a continuation of what the TRC was doing in bringing these proceedings into your home and making people feel involved. But the only way to do this would be to create something outside of the current system that we have. And that gave rise, since 2019's discussions around the Special Accountability Mechanism. It's a small piece of legislation. I encourage all to read it, because it's a beautiful piece of legislation. It's one that sets up or it's one that discusses principles. It talks about where we came from and how never again would we want to see such gross human rights violations in the Gambia. That is the Special Accountability Mechanism Act. It's a principled declaration, and it was an innovative suggestion from members of the Gambia Bar Association. We recognize them for that. We recognize the National Assembly for passing it. They could have received this piece of legislation and thought, what is this? We've never seen anything like this. But that innovation to say we're going to pass this law that doesn't create anything per se, but just talks about principles and values that bring us all together. Not only is it a principled piece of legislation, but it also introduces now the actual mechanisms, the actual institutions that will be rendering justice, that will be adjudicating TRRC cases. Thank you. Thank you, sir. So the Special Accountability Mechanism Act introduces three institutions or mechanisms. And so I like to think of the SAM as a triangle. Everybody knows, I think, Ida now doing the triangle. I've done this a couple of times. It's a good way to remember it, because a triangle, if you also know as mathematicians, all of you I'm sure, is a very, very, very powerful shape. It's mutually reinforcing, and I think works together in trinity, some would say. So there are three components to the SAM. There's a Special Prosecutor's Office. The Special Prosecutor's Office is almost like a merger between our police and the Office of the DPP, the Director of Public Prosecutions. Currently, it's the police that would investigate and the DPP's office that would lead in prosecutions. So you've merged that together, and now you have a Special Prosecutor's Office. This is best practice from the international tribunals, where they have the Office of the Prosecutor, oftentimes called OTP, where this office has both the investigatory as well as the case preparation and prosecutorial powers. So that's the Special Prosecutor's Office. And that is also law. That act has passed in April 2024, April of this year. Besides the Special Prosecutor's Office, we also have the Special Criminal Division of our High Court. His Lordship in January of this year created the Special Criminal Division of the High Court. He has the powers to do that under the Constitution of the Gambia. And this is a division of our High Court that is now mandated to receive post-TRRC or TRRC cases, or cases that are emanating from the TRRC recommendations, right? Now, what if, an instance, the prosecutions and the prosecutor realizes that this is not a domestic case, and therefore the Special Criminal Division of the High Court in the Gambia cannot rely on our domestic laws? This is where the Special Tribunal comes in as the third aspect of the SAM, right? So Special Prosecutor's Office, Special Criminal Division of our High Court, and the Special Tribunal. And the Special Tribunal is an internationalized court. It's a hybrid court. I wish Mr. Saliu Tal was here from the Gambia Bar Association, because he has an eloquent way of describing how it is a Gambian court. It will be a Gambian court, but it will be as international as we need it to be. We need it to be international to be able to invoke jurisdiction over international crimes, which our Special Criminal Division will not be able to do. So it will be international in that sense. We need it to be international in the sense that it will hire people from all over the world, because we will need expertise in areas that we haven't traditionally worked on, such as witness protection, victim participation, and just some forensic capacities, perhaps in the investigations unit, right? So that's the Special Tribunal. And in order to get a Special Tribunal, an internationalized court, a hybrid court, the government of the Gambia must enter into an agreement with an international organization. This is the jurisprudence. In fact, the ECOWAS Court of Justice ruled the same in the Habre case, that the only way for Senegal to have tried Hussein Habre in Senegal was to enter into an international agreement with an international organization, and therefore the government of Senegal decided to do that with the African Union. Here is where we are as a government today. We're looking to enter into an agreement with ECOWAS during the authority of heads of states coming up in December to give legal effect to a decision that would establish the special tribunal. So I hope that was a brief summary of the special accountability mechanism. Like I said, it has 3 components, 3 functions: special prosecutor's office. If it's a domestic crime, it can be heard before the Special Criminal Division of our High Court. And if it's an international one, then perhaps the prosecutor would present it before the special tribunal. And they're all working together, but as we will discuss today, at varying degrees. Whereas we're starting the setting up of the Special Prosecutor's Office, we're still negotiating the establishment of the special tribunal, whereas the Special Criminal Division of the High Court is ready to go. So they are different stages. And that is the simple presentation that we had today, but really to pass it over to you for us to engage perhaps over the next 20 minutes in questions and answers around this mechanism. I have with me members of the Joint Technical Committee between the Gambia and ECOWAS. Ms. Priscilla Yagusise represents the Alliance of Victim-Led Organizations on that committee to ensure that in developing the statute for the special tribunal, that victims' concerns were reflected. Mariama Singate represents the Ministry of Justice, but we have other members as well from the Judiciary of the Gambia, from the Ministry of Foreign Affairs, and then on ECOWAS side, we have members from the ECOWAS Commission as well as the ECOWAS Community Court. In total, there are 7 members of the Joint Technical Committee. 7? 11. 11 members of the Joint Technical Committee. So we throw the floor back for some questions and the possibility for Ms. Yagusise or Ms. Singate to answer and to dialogue. Again, like I said, we're all hoping for the statute of the special tribunal to be passed in December, and that means that the statute itself will be locked, would have very little room to amend parts of the statute, but in implementation, we would certainly take into consideration concerns to see how best to implement up to everyone's expectations. Thank you. Do you have a floating mic?
Okay, so if we have questions, please, this is the time for you to ask questions, and I'll bring the mic to you. Do you have
I'll take a bit of a step back for you to talk and ask. I'll take a bit of a step back.
Thank you very much, Ida, for that good presentation.
And what has been done so far. It's very important that we keep reminding. I think that's one of the purposes of this meeting. Not only the victims or our partners, but the whole public as to what
is actually happening in this transitional justice process and what government is doing in its efforts to implement the recommendations of the TRRC. Somebody like me, we receive a lot of questions and concerns from the public, not just victims, and I think this is a great opportunity to give an update. You've just given us a brief of where we are now. We know that the Special Criminal Division has been set up and is ready. We know that the the special tribunal is not yet ready. What is happening with the special prosecutor's office, and in terms of the appointments, it seems that that is what is holding up at least the special committee. So it will be good. I know efforts are being made. I know personally what has happened so far. But just as much as you can say about the appointments and the establishment and getting the special prosecutor's office working to commence some form of prosecutions. Thank you very much.
Good. Yeah, good. You can talk, yeah.
Thank you very much.
I think you can keep these and float them in the... We have mics.
In respect of the Special Prosecutor's Office, we have actually constituted a selection panel as per the Act. And this panel comprised of international experts, and among them is our renowned Pat Bensouda, Stephen Rao, and a judge from Kosovo, and other individuals that are experts in that field. The selection panel will actually be responsible for the recruitment of the special prosecutor and all the important members of the special prosecutor's office that require certain specialization areas. You know, we are not experts in this field, and like Ida highlighted earlier, we would need international experts to ensure that our process, just like the TRRC, is also successful. So in so doing, we are following the steps provided under the Special Prosecutor's Office, which includes the selection panel, who will now recruit members of the Special Prosecutor's Office, and after that, then they will operationalize the office. But this was sometime, I think about 2 weeks ago or so. Yes, they've started work already. So they're working on the TOR and the modalities for that. Thank you. I avoid giving timelines because I am not a member of the selection panel, so I can't say for sure. But given the level of expertise of the members, I believe hopefully very soon.
Thank you. As the Secretariat, we sit in all the meetings, and they have given themselves 6 months to go through the recruitment process. Of course, this is dependent on how many people apply, and eventually negotiations when selected persons would move to the Gambia, if they're not in the Gambia, that is. Now, when we said that the idea is, when we said that the idea with the special tribunal is to be as Gambian, that it's Gambian but only international as possible, that applies as well for the Special Prosecutor's Office. Actually, for all of justice, everything we're doing in the Gambia. So by no means, when we say that we're looking for expertise that may not be available here, that doesn't mean that there won't be any Gambians working. Definitely not. It's Gambian first. Maybe ECOWAS citizens thereafter, and then international, just to retain that local ownership that is very important, and as we know, has given success to our truth-seeking process. But the selection panel has given themselves 6 months to complete the recruitment process, and as a secretariat, will support them in that, in advertising, both locally, internationally, in shortlisting, in interviewing, and in eventually to giving offers. An important component of this is making sure that the office has a budget. And so, as we're all aware, we're currently going through our budget negotiations to ensure that there is a budget that's available for the office when it starts. But we also know that because of the issues we're dealing with, forensic work, investigations that would have to happen, the identification, DNA, and you name it, we're also talking about a capital-intensive process if it's going to be of international standards. And so it's not just about selecting the people that will man the office, making sure that they have an operational budget. We also have to mobilize resources quite a bit with partners as well. So those efforts are also ongoing. I think an important message for all of us to bear to believe in and to replicate is that the Special Prosecution's Office is not married to the Special Tribunal, that local cases can start, if they are local cases, between the Special Prosecution's Office and the Special Criminal Division, 100%. So we need to divorce the idea that if we don't have an internationalized tribunal, that there will be no investigations, that there will be no prosecutions. No, there will be investigations. That's why all attention, right, and all effort needs to be made in setting up the Special Prosecutor's Office as quickly as possible and resourcing it so that they can do their investigations and prepare their cases to the highest of standards. So the issue of their resources is really important, and we're committed and believe that the government will be putting as much as it possibly can in this process, just as it did with the TRC. The TRC overall budget was $8 million over 3 years. And 3 million of that came from the government, and 5 million mobilized from various partners. So those are the efforts that are currently going on for the Special Prosecutor's Office. Yeah, thank you, Mariama, too.
Thank you very much, Ida and team, for the presentation. And thank you, Ida, also for this clarifying also that prosecution doesn't, we are not waiting for the special tribunal to start. It's very important for us to be reminded that local cases can start as soon as possible. Now, I want us to speak on the issue of timeline. On the implementation plan, we're looking at starting in 2025, which is around the corner. How confident are we in that we will start prosecuting, whether it's local or international, in 2025? If not, how can we start considering looking at maybe adjusting the timeline, which of course will adjust the budget? If you can speak on the timeline, please, when it comes to prosecution, because the expectation is that we will be starting in 2025, or the plan was that we start in 2025. You can speak on that, please. Thank you.
Another question.
If I may be allowed to put in a second question?
Yeah.
So also on the issue of clarification. Recently there's information, of course, on social media that all the $150 million that is budgeted for the implementation plan is just for the prosecution of Yahya Jammeh. So if you can please you may not have that on the top of your head, but if you have a budget breakdown on $150 million, where it is going to be spent. Of course, I know, but just to clarify, especially for victims, who this information was directed towards, the entire $150 million was being spent on just prosecuting Yahya Jammeh, whilst only $4 million was being spent on reparations for victims. So if you, by any chance, have the numbers, if you can just clarify also on the breakdown of the $150 million, that is, I know is for the 5-year budget for the entire implementation of all the recommendations. Thank you.
Yeah. Absolutely. I think you answered the question itself, that the implementation plan covers all the 263 recommendations by the TRC. About 44 of those recommendations are about prosecutions and criminal accountability, 44 out of 263. So the entire plan is costed at $150 million. I cannot tell you exactly how much is budgeted or towards the criminal aspect. I'd have to look into those numbers, but no, it's the entire plan. So memorialization, reparations, institutional reforms, that is reforms of the prisons, the judiciary, the Ministry of Justice, the SIS, NIA, formerly NIA, the whole plan is budgeted for $150 million US dollars. And to be implemented, as you said, over 5 years. In terms of timelines, I think we take note, certainly, no one has to say, but we take note that the implementation plan is behind schedule, right? Every time I meet Keba Seka in the room, he always reminds, and that's true, it goes without saying that we're behind schedule on implementation. And so we have to try as much as possible to catch up. But I think also in that process of trying to catch up, it's important to still do things properly. So to go back to the question about how long would prosecutions take and whether they would start in 2025, I have to say it's going to be the discretion of the special prosecutor. And what the government were doing as quickly as possible is setting up that panel and supporting that panel to recruit the special prosecutor. But that special prosecutor, if we read the act, has all the powers to really predict how investigations and prosecutions are going to happen. So I wouldn't want to predict what they would do or what they would say. It would be inappropriate. But for certain, the message would be given to them, and I'm sure not just from the government, but from Victims Association and all partners, that we're behind schedule and that there's really a need to expedite everything as much as possible, noting that they're victims, many of whom are critical witnesses that are passing away. So really time is of the essence, but I wouldn't want to predict unless my colleagues want to do the predictions. No. Timelines are a difficult one because as we're all aware, whilst we have these plans and ambitious and rightfully so, there's always the issue of resources. So you may be ready to do something, but you have to spend that time looking for those resources as well. Yeah.
Good morning.
Please, someone else take the next question, so it's not just me. So it's not just me talking.
It depends on the question.
Everybody. Good morning, everybody. My name is Keba Seka. I am a victim and a victim representative of the exile legal community. I have a question, and that is I would like to know whether plans are in place for decentralization of the operation of the Special Prosecution Office. In case that has to be happen, it will help those that are in the other regions of the country. Just want to know whether plans are in place or is it going to be centralized? Thank you.
Thank you, Keba, for that question. I believe that the office of the Special Prosecutor will be central in the Greater Banjul area, but obviously the Special Prosecutor will engage the communities. So in engaging the communities, there will be some form of decentralization in terms of advocacy and also investigations, like going into the communities, obtaining witness statements and investigating on thematic issues. So definitely the Special Prosecutor will be engaging victim communities and other relevant institutions. Thank you.
Hello, good morning. Thank you, Ida, for the presentation and the rest of the Joint Technical Committee. My name is Farmer Jawni. I work with the Bakery organization. My question is very brief. I'd like you to set up backs on our efforts to establish this
Thank you. Thanks for the decision that was communicated which did not go down very well in the country, especially with Gambians, victims community, the government as well, because there's so much work had gone in prior to that in terms of communicating what the ECOWAS hybrid code would be, what it would entail, and how it would be beneficial, not just for Gambians, but in terms of other West Africans who were impacted by human rights violations that have been committed on Gambian soil. So what we had from ECOWAS at the time was really not that it rejected, but it gave an unfavorable opinion, an opinion which nonetheless resonated across Abuja. First, we had a number of representatives, members of Gambia's ECOWAS Parliament, right, who were there and had been doing a great job in trying to push forward this agenda so it would stand. We had the Minister of Justice was there? No, he wasn't, but we had other government representatives who were there. And it also resonated here in the country and across a number of West African countries as well who had a vested interest in this. In addition, the global stage, because so many people have been waiting to hear. I think it wasn't foreseen that that would come through in the way it did, and I think there were a lot of miscommunications and possibly the way in which some of the information was shared was not received the way it should have been received, and I think there had been some gaps and lapses in terms of briefings. We were quite confident that this would come through. But then, nonetheless, and has been mentioned earlier by the Solicitor General and Legal Secretary, the ball is still in the court, and in December, when the heads of state would meet, there's another opportunity for that decision to be revisited. And right now, different entities, both in the Gambia and in other jurisdictions, are ready, on standby. The lobbying's being done, the networking is being done. Members of the JTC, we have been to meet the Minister of Defense, we have been to meet with the National Assembly, and other Ministry of Foreign Affairs and other stakeholders to have briefings with them and just enlighten them on what the whole process entails and how they can contribute to work in supporting that, including with their counterparts. And there's a lot of support from that angle at the Gambian side. So we're well armed and ready to go back for another round so that that unfavorable opinion, which was communicated in July, would be reversed, and the support for the establishment of the ECOWAS Hybrid Code Tribunal would be in place. Thank you. Yeah.
Thank you very much, Priscilla. If I could also just add to what you said, thank you, that indeed it was uncomfortable, very uncomfortable to hear from a parliament that our request to establish an international court that can just look into, that can adjudicate serious crimes that may have been committed here was not wanted. And I think it goes to suggest that perhaps there was just a lot of misconceptions. It's very hard to believe that anyone would say that, right? So yes, as Priscilla mentioned, ECOWAS is a big organization, like the United Nations, and there are various organs. The ECOWAS Parliament is an organ, and the ECOWAS Commission is another organ. The organ that has the power to make a decision on this is the authority of heads of state, not the Parliament. It's a complementary process. Anything that's to be tabled before the heads of state will go to the Parliament, depending on the issue, sometimes for an advisory opinion. So in this instance, for an advisory opinion. But it's not a binding, it's not a decision. And that's why I take a bit of, we're careful to call it a decision, we call it an opinion, because it means different things. But yes, so the question is, did the authority of heads of state reject the Gambia's request? And the answer to that is no. The authority of heads of state did not even consider our request. It never made it there. And it didn't make it there because of procedures. There's something called the Mediation and Security Council that sets the agenda for the heads of state to consider whether to approve or to reject, right? So it's at the Mediation and Security Council that the memo on the Gambia did not pass through. And it didn't pass through, well, really because of procedural glitches. I can give you the details, that's why we're here, which is to say that procedurally, this is how it should go. That firstly, experts from the various ECOWAS community countries will meet on the document and approve a report. Following that, the ministers of justices will approve that report, following which the ambassadors will approve the report of the ministers of justice and set the issue on the agenda for the ministers of foreign affairs and defense. And once it passes the ministers of foreign affairs and defense, it then goes to the agenda of the heads of state. So those are the steps to follow. And in our case, we held the experts meeting here in the Gambia, 10 to 12th of June. The experts approved the statute and the decision. And really were very supportive, I have to say, of this process. You have countries like Liberia that are looking to do something in their country. You had Sierra Leone that was very supportive as well. Cabo Verde, many countries were really supportive and applauded the bold move for us to establish a special tribunal. And then the ministers of justice were supposed to meet on a certain day. But unfortunately, we didn't have quorum on that day because of internet connectivity issues. In fact, just when the meeting ended, that's when one of the ministers of justices signed on and said, hello, hello, and we said we had to postpone the meeting a few days forward. So because the ministers of justices did not meet on the report, and the next stage was the ambassadors' meeting. So the Ministers of Justice's initial meeting was supposed to be on the 19th of June. But they couldn't meet because of no quorum. And eventually the rescheduling took place on the 2nd of July, or the 3rd of July, whereas the ambassadors met on the 2nd of July. Now, of course, in retrospect, and retrospect is always the best teacher, right? Of course, in retrospect, we would have done a lot more, of course, for the ministers of justices to meet before the ambassadors. But these were procedural issues that were never mentioned to us. So there's really a mixture of not understanding the ECOWAS process, not having been advised thoroughly, and unfortunately missing that opportunity. So when the ambassadors met, they said, we're not sure whether we can put this on the agenda because typically the ministers of justices would have approved a report. And so when it went to the ministerial, the ministers of foreign affairs and defense as well, they said similarly, we can't put this on the agenda for the heads of state because our ambassadors equally have to endorse it. So it's very frustrating that that's where we are. In terms of whether it's set us back, I don't think so.
No, I don't think so.
Yeah, I mean, this has been discussed. Yeah, this has been discussed extensively by the JTC. And noting that the Special Prosecutor's Office is where everything starts, it hasn't set us back in that we continue to establish that Special Prosecutor's Office. That's where, even if we had a special tribunal today, they wouldn't also be able to adjudicate cases like the Special Criminal Division of the High Court. There are no cases going there yet because they must first be investigated. So all effort, again, must come back to the Special Prosecutor's Office being equipped so that the investigations and the case preparations can start. So it has not, in terms of timeline, set us back. But it has revealed a lot more about how ECOWAS works. It has also, in that process, revealed what some of the misconceptions are about the Gambia's requests. Some member states think that they're going to have to fund the tribunal. That's not the case. The request is simply a political one to endorse the decision. There's no obligation for funding that comes with the request. Some have said that ECOWAS cannot be a referee. Again, that's a misconception because in order to be a referee, you must be a part of the game, and they're not. This is establishing an independent institution, a brand new institution where the staff will not be ECOWAS staff. It will have its own recruitment processes. It's a court, and in fact, the court itself is the referee, right? There will be parties bringing cases and it will be adjudicated there. So it's not ECOWAS. So I think it's given us opportunity to also understand that there's misconceptions around the role that ECOWAS will play, around the obligations that it will have for ECOWAS. But all in all, I think we all agree, and I think even the member states agree, that the notion that somehow people's determination for justice and accountability should not be honored, I don't think that is what the Parliament really meant to insinuate.
Before we continue, yes, I was just informed that we have some participants and victims here that cannot understand English language. So if maybe, Madam, you can somehow summarize a little bit, or we can, interchange or switch so that they can understand what we are discussing. Before I come to you, sir, we have a lady here, and I'll wish to you. Thank you.
Yeah, thank you very much for that presentation. My question is around victims and witness protection, obviously. So what strategies are in place? What strategies do the special tribunal have, since we're dealing with very sensitive issues? So are there strategies for witness protection? Thank you.
You want to take it? Yeah.
Yes. The Special Prosecutor's Office.
The languages, if you don't mind. Yeah.
Which Aisha can translate.
Special tribunal bi ndax am ngeen strategies yoo xam ne dina protect victims yi nga xam ne dañoo ñëw si special prosecutor bi, knowing that ne seen information yoo leen a deal with dafa sensitive, so victims yi soxla na ndax am ngeen strategies boo xam ne dina leen protect pour lépp loo xam ne war na leen a lor, ndax tribunal am ngeen strategies yooyu noonu.
Jërëjëf Aisha. I think about another question. It ends there. It's jërëjëf and bye-bye.
Good morning, everyone. Good morning. My name is Adaman Cham. I am from LRR. So this special accountability mechanism, you said you have a special prosecution office and special criminal division, special tribunal office. These are the stages the victim should know at which stage what you should do. I don't know whether you have a legal advisor that will be able to educate the victim so that they can know at which stage what should you do before the session start. Yeah, thank you.
You want to take the second question? I'll take the first. Okay.
Translator.
Mr. Bojo is speaking.
Okay, ndetomo adama chamle mbora LRR ne. Ngamen fo jam ngani ngaro minke coming iko call men fenko men mina start la den coming mina code men start la den. Ya fo coming da sabal lebeje me alonko inyana pour kawolke. Wolem force one special prosecution office. Say ko victim ol nyanda lon nale special prosecution office. Inyana munikela je. Flanja ngo fanang special criminal division. Special criminal division ñanda lo na special criminal division ñanda mune fana ñanda taman lawto ani ñanda mune kala je ani sama ñaw special tribunal office mune mala dogodi victime ol fana ñanda wolo na sa ni along pour ndinkito be kala abe soni ala because mo ni fengolong ibalo na ba taman la ñame ba ni mam fengolong abe ko ala pour ba taman la
Baraka Bake.
Good morning, all. My name is Abdullah Bojang, a father to the late victim. I don't want to mix up apples with oranges, but this is part of victim's perspective. some time ago, nine NIA members were put on trial. And one or two other trials took place. Then a jungler by the name Bora Koli sneaked into the country. He was later delayed. Why can't he be put on trial? If that did not exist, why should he be detained up till now without being charged? Most of the victims assume that he might be delayed for some time and be bailed out, like how other junglers were on the street. We would like you to put some answers to that. His affairs has been quiet since when he was delayed. The victims and the community did not know exactly what's happening with him. Thank you. Nanginin karo minti walem nyinti komanto nung 9 inmates walem NIA 9, excuse me, NIA 9 mo konon tolu ye mutanun jang ye kitindi mbenya la jang ye solong ni kiti dantanu fana keta kabirin TRRC fana sita ngaje Bora Koli nata adunta na malabuta daming adunta na Gambia jang Masakunda nata muta. Actually, mka trust le jube, Masakunda abinyikiti o mbe trust totale je nyadi le nka wole jube, inata ya muta. Edu ni mo muta, inyata samla kiti yolale. Muna na iba muta la, aitala soronde mola miro, tumado nyato iba bulalale, aitala firiri nko jongla dolbe firiri nyami. Nga tabul tonkol nyine nka wala. Ntoma Abdullah Bojanet, Allah.
Good morning.
Good morning.
My name is Balo Sidikan, a victim of November 11. My question is, why all perpetrators can be prosecuted? A, is it because of the lack of evidence or because of lack of mechanism? 2, Mariama, during your deliberation, you stated Fatou Bensouda to be among people lobbying or trying for possible judges or what. And I believe, I'm not saying she's a victim, but April 10th, 11, she was the Attorney General, and the Indemnity Act was during her time. So in order to protect this special tribunal, like the critics that TRRC went through, I think it's better we put up something that at least will guide the special tribunal. Thank you. Ngame nyininka wala nyindinko mune yantina mol me yalanko yeman toro la mol kang ite be kitin lano fo luwa la be je mem man tara de daring wala fo ye tinyaro menke ye problème menke wala man siya wala man wara baake bang fo ite kitin lano fulanjango Mariama la diamo kono ako ay Fatou Bensouda to foje pour ka mako roke pour ka mendo be kiti kala pour ke identify nko ma foko perpetrator le monde bari minister le monon at the time of April 10 11 dum bribe loi bonde la menni o ke pour ka yam fawole wata be minister ala le so ndung nyanta katala TRRC komo siate kambake bawo modol be je ka fako perpetrator lewu bari nata tra TRRC kono so nga try bawo special tribunal nying lafta le pray tilingolondi anin tonya pour nyin kamala sama menke da kanake kotake woton kana som ku wole membe falama me alon ka be mbaran la sama ala barka.
He'll be the final participant, and then we'll just answer, move on to the next. Thank you.
Yeah. Thank you. Unfortunately, I won't be able to give a very good response in Wolof. Should I try? Aisha, the National Victims and Witness, Victims and Witness Protection. But you're the next. Oh, seriously. All eyes on me. Then you have special accountability mechanism. We provisions. More in witness protection. Dina when hamne dina dego legal investigations need of prosecution. So lolu min na ne ñi taxawal fofu ak victims ñom sen bopa dinañ am protection. Dinañ am protection si walu ne sen lifin su fekkee ne waruñoo feeñ dinañ am protection boobu kon fan naa ñu bari gisoon nañ ne si during time TRRC bi am na ñu bari ñi nga xam ne ñëwoon nañ waaye naka protection mechanisms in in place lifinuton noonu. So in addition to the SAM, at SAMBE, National Human Rights Commission with support from the American Bar Association, ABA, Nyungi developed the National Victims and Witness Protection Policy. The policy board, just as provisions in ECAC special accountability mechanism, Nyungi different guidance you have in a support. You bari ñi wara ñew pour wax yefi liñ gis liñ xam li leen daaw su fekkee ne ñooñu ñëwoñ then duñ mëna am a legal process duñ ko mëna am parce que foog nit nañ victims nit nañ witness pour ñu taxaw pour ñu mëna am prosecution, whether it's prosecution for all or prosecution for some, but definitely that is needed. So lolu witness protection bi mong fa the provisions in the National Victims and Witness Protection Policy, the National Human Rights Commission, they finalize under the SAM. Lolo amna special protection, special provisions bu jigéeni ak pour xale tamit, very child and gender sensitive. In addition, ñu ngi am access to defense services, support for legal aid, support for mental health and psychosocial support tamit pour ñi nga xam ne dinañ am pour ñëw waxtaan ak gaay. Then yeah, so I think in short what I was trying to say is that the SAM, provisions in the SAM, as well as the National Victims and Witness Protection Policy, which is under development through the NHRC with support from ABA, American Bar Association, that has really tight and very comprehensive provisions for national witness and victims protection. The policy is done, actually it's been validated, it's been adopted. Just some step-down training programs are now in place, which Ictj is also supporting. And those provide really wide and broad provisions for all of those who would be taking part as victims and witnesses, because we really need their participation, otherwise we will not have prosecutions. We will always not have also not have a legal process that be ongoing. And they cover a lot of critical provisions, including on children and gender provisions, legal aid, as well as mental health and psychosocial support. And that also covers in terms of having to decentralize if need be. But the policies are there, so maybe what we would do, I think, when Ida was talking earlier, it came to mind that a number of people don't have these documents, which are there, they're widely available, so we need to just get people engaged. But I think possibly Ictj, that has the email addresses of those participants who are here, who have email accounts, we would send it to them. For others, the AVLO will take it upon ourselves to send to the
membership of those who attended and the victims community, so that they would get copies of all of these documents and they can engage with them. And questions would also be forwarded to organizers, the MOJ, and other interested stakeholders. Thank you.
Thank you very much. Please put your hands together for this amazing session. All right. Okay, please go ahead.
Thank you very much. I'd first like to respond to Mr. Balukan in English, then in Mandinka. In respect of Fatou Bensouda, there were no adverse findings against her on any violations of that sort. Her expertise is needed as she's an expert in international criminal law and she's a Gambian, and the Act does provide that individuals that are to be part of the selection panel are to be individuals that are of integrity and have no adverse findings against them. And that is the case with her, and we are fortunate to have someone like her that has wide wealth and expertise in that area, and that expertise is what is needed to get the right people to drive this process. Comme min fokan nu Mr. Balukan la nyinin karo la wala ba nyinin karo kele ka foko Fatou Bensouda amunu minister letinu njang during November 11 prepare molia ke selection panel nga file ko kabin TRRC la kiskis roke e man kuje ko atela ke mi alon ko alata tem kam mol mantora ke tajiriya ha to nyala minister ti bare mol man kuje be pare Gambia no la mi alon ko ay ham soto nying cool mol nyanta minkela wala tinna ye opportunity diala parce que na Special Prosecutors Act fana ya folo ko mol mi ya lon ko bolde nyanta tombondi rogal e nyanta kala mol mi ya lon ko tilintale be pare do ko lo ne ba min kala wala tinna abo bundato kana mbarin kela nyinin karoto nyin kana mbarin kela nyinin karola nyin victimul la rulula nyin processo be na set up da ibo victimul engage la comme ngal engage nyum nyali from the beginning kata TRRC to kana even kanyin lual develop mole victimul engage le ni nyim processo be set up iba victimul engage la le kotenke parce que molta tala no without the victimul le ka evidence will provide comme nambari muso Priscilla ya fo nyamen ko hani nimbe engage la mba kantar cool nyin la dila kaje ko la nyantol ngi kantale ani process o ni bitala jenteri victimize la kotenke. Just as I was responding to him in terms of victims' roles and responsibilities, just like we did at the TRRC, victim engagement is key in this process. Victims were engaged during the legislations when we were finalizing the legislations and the special accountability mechanism and the special prosecutors mechanisms. Their input were taken on board, and just as the same way, once these institutions are set up, we need victims to drive these processes, and they're going to be engaged. Like Priscilla highlighted, there will be an office responsible for victims, and they will engage the victims, and there will also be some protection mechanisms to ensure that victims are not re-victimized and they are protected during the process. Just to clarify as well, my colleagues did point out something to me, just to clarify that Fatou Bensouda is not a candidate for the Special Prosecutor's Office. She is assisting in recruiting individuals for that particular office because of her expertise in that area. I hope you do understand that. Thank you very much.
So, yes, madam.
Thank you very much.
No questions, please.
I think thank you.
Yeah. I wanted to actually reflect on the comment about an alleged perpetrator because he was accused committing crimes
during the TRC proceedings. Just to say that the truth-seeking process is very victim-centered, and all of TJ is victim-centered. But when we come into criminal accountability, it's also very centered on the rights of the accused persons. And we have to start being comfortable with that quite early on, that it was everyone's prerogative who appeared before the truth-seeking process to speak as you wish about whatever you wanted in whichever manner. Your agency was very important. But now that we go into a criminal accountability process, there are really strict rules on that. And it is quite centered, I have to say, as well, on the rights of the accused. So it's not a TRRC at all. It's a court process. And for that reason, Mr. Bora Koli, I believe, is being granted those rights that he is due as an accused person. We can't speak on the content of the investigation. That is left for the Office of the National Security Advisor and the Office of National Security. But as an accused person wanted in criminal proceedings, there's certain rights that he has to be afforded. That's all that I know, in fact, because the investigations are continuing. But I think a good way to maybe summarize, because we take note that there's a panel supposed to speak that continues this discussion about why are we even doing this? I think we're actually moving into that state of mind as to why are we even doing this, despite all the challenges, despite what may end up being some disappointments about accused persons, perpetrators, being afforded a platform to defend themselves. I think just to get back to the main message, that it's absolutely necessary to do this if we're really going to reconcile as a nation. We must stop to assume people's guilt and move on to prove individual guilt. Yes, I think that's very important. So with that, we want to thank you for affording us the opportunity to dialogue with you. This was just an intro into what the Special Accountability Mechanism is about. And now we will move further, I think, into the program to speak more so questioning whether this is the right way for us to go in terms of the setup of the Special Accountability Mechanism. Were there other alternatives? Were they considered? Why were they not in the end opted for? Thank you very much.
Okay, thank you, Madam Anya. Before you wrap up, please, just a quick one on the youth, actually. They said, how can young people take part in this mechanism? And it's coming from the Nation, Our Voice Youth Organizations, so that we cannot leave behind the youth as well. They need to be involved, so they're asking, how can young people take part in this mechanism? Thank you.
Thank you. It reminds me of the question that was sent to Francesca Albanese recently about the right of Israel to exist. And she says, Israel exists because it exists, right? It exists. So young people participating in TJ exists. You are participating. You are. Maybe the question is more, how do we ensure that there are young people in positions of authority? How do we ensure that there is a gender-sensitive approach to investigations, etc., etc.? But if the question is about participating, I mean, we're participating. I think I've fallen out of the youth category in recent times. Mariama, I think you too.
No, I'm still.
You're in the youth category. Just to say that, if, however, what we should look at is how do we ensure that there are more young people sitting in positions of power, making decisions, and that when we do activities that we're mainstreaming young participation, certainly. So for example, I'd speak on the SPO, now that the selection panel is sitting, they are looking into these issues as to how do we not only get the best experts, ideally Gambian experts, but that we also get as many young people as possible in positions of power. There are considerations that are streamlined across the Reparations Commission. 2 of the commissioners must be young people, for example, yeah. So we look forward to working closer with our voice, our nation, to not just get young people participating, but making the decisions, yeah.
Thank you. Round of applause for this amazing session. And at this point in time, we'd love to have a group photo outside, and then when we come, we're going to finalize the session. Thank you. So there will be a lady outside to coordinate the photo session.
Priscilla, thank you. It's excellent. And I'm sorry about having to speak Wolof. I would never do. You are so brave. Priscilla.
Thank you, guys. You guys are doing amazing. Thank you. having the photos. And I love the smiles that all of us gave for the photos. Thank you very much. Let's have a seat as we soon wrap up because we're running out of time. Today's Friday. If you're outside, please just have your seat. Thank you. Okay, ladies and gentlemen, if you're outside, please, can you just take your respective seats and let's just continue the session. Okay.
She's connected.
Okay, that's fine. Okay, at this point in time, we'll be having a panel discussion. The special accountability mechanism is necessary to secure justice and accountability for the post-TRRC phase. Yes, please. And as you've all seen, there's a name tag, table tag, sorry. So if you just see your institution, please just have your seat and let's start the session. I love working towards time, so apologies for you not giving your questions because I just love working towards time. Apologies for that. Okay. The first, for this session, we'll be having experts that will be handling this session, and we'll be having, the names are Mayema Singate from MOJ, Nene Cham from GBA, Manso Joe from NHRC, Anne Marianne Rukatel from Ictj, and Sira Indao from AVLO. And we'll be having the virtual one first, and that is Madam Anne Marianne Rucatello. Yes, and she's already connected. I hope I hope I pronounced your name very well. I did. Yay, UPA. All right. So, ladies and gentlemen, we're going to start off with her because she has been with us for a couple of minutes or so. So we want her to do her presentation first, and then we'll let it go on to the others. Technical team, are we set?
Can you hear me?
Yes, please. Go ahead. Good morning. Thank you.
Good morning to you. I actually had the pleasure to follow a good part of the previous session. So let me start with giving you a warm welcome. I'm very, very happy to see such a great attendance. And I was very impressed, not only by the presentations, which is no surprise given the caliber of the previous speakers, but also the questions. The questions that already, in my view, illustrate that there is that very deep understanding and social energy, as we call it in Ictj, for not only the establishment, but the pursuance of accountability in all its forms. So I understand that this panel tries to discuss actually why not only the criminal accountability element is important in a transitional justice project, but specifically
the mechanisms. So what type of mechanisms are the best suited for such an endeavor? And as we have discussed until now, the Gambia is equipping itself with with institutions and authorities that are certainly in accordance and in compliance with the best practices that have developed in transitional justice over the decades. So we all know that in a context that has regrettably experienced such a widespread violence, political violence that translated in gross human rights violations, the normal institutions, the regular rule of law institutions are put at a great test. And they're not generally, even when the level of institutionality in the relevant country has not been particularly impacted or irrevocably impacted by the conflict or a dictatorship. Nevertheless, those institutions, when they remain, are not generally suited to investigate and try those crimes. And the main reason, besides what may have happened in terms of resources, in terms of depletion of the human capital in times of violence, it's because the institutions, when that represent the state, which is in some forms and ways complicit and implicated in the commission of those violations, lack legitimacy. And it's not only when the state agents are directly committing or have directly committed violations that happens. It's also when the state has failed to protect the civilian population has failed to protect the individuals from those violations. So the deficit of legitimacy is what really one of the main reasons why it has proven imperative in transition transition context to establish specific remedies, specific processes, specialized jurisdiction that are newly established with the participation of civil society, that go through the scrutiny of society in order to start their work with the trust and the support of those that those institutions are mainly meant to serve, which are the victims. The other, of course, reason for establishing specialized institutions within a criminal prosecutions in order to address, with the mandate to deal with gross violations of human rights that occurred during the period of political violence is the capacity. Capacity not only in terms of numbers, the resources, the human and financial and infrastructure resources that are required to initiate and maintain and support an endeavor, a criminal prosecution that in order to be effective and impactful in a context of transition must last, not for 2 or 3 years like a truth commission, but most probably longer. So what the capacity I talk about is really the knowledge and experience to deal with those type of crimes. And we need to demystify a little bit what we mean by knowledge, because in no country in the world, there is an inherent or immediate ability to try to investigate and try those crimes. Not in the most established democracy, not in the most developed democracy. These are, like other type of international or transnational crimes, very specific type of offenses that require a specific expertise, which is not present unless the context and the jurisdiction acquires experience in those cases. And therefore, it's not unique, it's not unprecedented, as you perfectly know, and it's very necessary that any country, any jurisdiction that finds itself in the need to address and to deal with those cases establishes specialized jurisdiction, specialized prosecutorial office, exactly as the Gambia is doing, trying to draw from experience which is available in the country and outside of the country. From the questions that I've heard, you have already identified the most critical issue, which are the sustainability, first of all, the legitimacy, making sure that these newly appointed specialized professional in the prosecution office are trusted and regarded as individuals of knowledge and integrity. And the Gambia is already trying its best with this selection panel to ensure that. The witness protection, which is a critical issue, and even in jurisdictions with ample resources, that remains a problem. The Gambia is a fairly small country where individuals and communities are known and they know each other, and therefore the protection of individuals is a challenge, would require in some cases cooperation with foreign and neighboring countries in the most severe cases when there is no alternative but to protect the individuals or the witnesses in environments that are not the Gambia proper. This requires a great involvement from communities and civil societies, because the change of location, the change of environment is very costly, requires cooperation from neighboring countries, as I said, in the best case scenario, and cannot therefore be a common element. The protection of witnesses and victims needs to come primarily from inside, from a technical point of view and from a resource point of view. Hence, the importance of communities and other services that are there, including social services, including medical services, that need to be aware and involved in what it means to protect holistically individuals that are involved in these formal proceedings, in these very sensitive, traumatic, sometimes type of legal proceedings. Now, the other issue that somehow transpired from the discussion before, and it is very critical, is the connection, communication, outreach to victims and society at large. Now, we are speaking primarily from the point of view of a newly established specialized prosecution office, which is one leg of the proceedings. It is the office that, because the mandate is very clear, which is to pursue accountability and therefore to be on the accusatory side of the process, can have a more clear type of communication with all parties. An adjudicator, a judge, would be obviously in a different position because it needs to maintain that impartiality towards all parties of the proceedings, to also respect, as was highlighted before, the rights of the accused. The prosecution office is of a different nature, and therefore can have a more transparent, sometimes closer relationship with victims and communities that are involved. They are supporting, accompanying the process. But it doesn't come as easily as it sounds, because, as we know, one of the principles of criminal prosecution is also to maintain confidentiality and the integrity of the investigation, and therefore what to communicate, how to communicate, to promote that principle of inclusivity, and to make sure that the process of criminal accountability is reparative in nature by including and communicating with the victims and the communities is a challenge. And again, it's not something that we prosecutors wake up and know in the morning. It's something that we have to learn. We have to learn, and we need to attune and to develop our skills in dealing with victims and witnesses as we go along. It requires also a preparation that goes beyond the technicality, the technical legal issues, in how to maintain the trust and the respect of those we serve. And therefore, when we, for example, speak a lot in transitional justice remedies of the importance of psychosocial support, well, you know, it came very late in the game, but for sure, even in a prosecution office needs to be accompanied with the tools to be able to communicate and to deal with not only the immediate parties that are involved in the specific case, but also the larger society that has a keen interest in the case. And talking about case, and this is the last element, the last thing that I wanted to say, because regrettably I have compelling other meetings that are piling up. So the last element that I want to raise, which is the one that probably I have not heard in previous discussion, but it is key in criminal accountability in transitional context, is the selection of cases. There is, in a transitional context, there is no possibility for any remedy, whether judicial or non-judicial, to be able to deal with the entirety of cases that unfortunately the context has experienced. The number of offenses, the different nature of offenses, the different types, groups, and peculiarities of victims. So, what is the principle of one of the main principles of criminal accountability in transitional context is the so-called prioritization or selection, prosecutorial selection of cases. It is not a principle that comes free of cost, because in criminal accountability, the prosecutor's office, as a prosecutor, I was under that, I swore to that principle. We are sworn to prosecute all offenses that come to our knowledge. We are the representative of the state and the protector of of those in that jurisdiction that have been violated. In transitional context, however, the sheer number and nature of the cases makes that impossible. Hence, the complementarity of different transitional justice remedies. How the prosecution office identifies the cases that will take upon itself to prosecute, and how the prosecution office communicates the criteria of that selection, the reasons why certain cases were identified and selected for investigation, becomes obviously a crucial matter that can become very controversial, that can frustrate victims and society. It needs to be transparent in the criteria, not what is being done in the case specific once the case is selected, because that has constraints of secrecy and for the effectiveness of the investigations, but the criteria and how the office progressively advances in selecting those cases and advancing those cases need to be very transparent. Because, and with this I conclude, the biggest challenge for the criminal accountability in a context of transition is to select those cases that are truly representative of what has happened to the countries and to the individuals living, residing, and trusting the state organization of that country. What has happened and why? And therefore, considering that we are very limited in our ability to prosecute a sufficient number of cases, the cases that are selected need to speak to the country, need to provide, to contribute, not to provide justice in themselves, but contribute to provide justice to the most representative sectors of the society, in targeting and illustrating how, in your case, the dictatorship has established a system, a criminal system of violations of human rights, how this system was financially and socially supported, and the consequences of the different violations, how they harmed individuals, community, and the state as a whole. So, I would love, because this is my subject, I would love to stay with you and learn from other colleagues in the panel and the audience. I apologize profusely also to my colleagues and my office in the Gambia for having such a limited time. But I woke up at at dawn just to be able to get the gist of how you were going and what the discussions was. I really have another meeting waiting for me, but I wish you really from the bottom of my heart all success for the day, for the discussion, and the reassurances that Ictj is truly at your side in this very important and critical phase of rebuilding a beautiful future Gambia. Thank you.
Thank you very much, Madam. I call Tilo. Thank you so much, and I'll be having the next expert panel.
That is Mariama Singate from MOJ. Thank you.
Thank you. Good afternoon now, everyone. My name is Imran Dabo, and I'm moderating this panel discussion. First of all, I would like to say thank you to Anna again for sharing from that depth of knowledge that she has. And I always say, you recognize the passion that certain people have for what they do, and you understand how then they can go on to push and to achieve so many things in the space that they work in. And Anna has always been, from my experiences, really passionate about transforming, societies through transitional justice work. But I also have here with me a panel of likewise really passionate personalities who have contributed. Like Ida said earlier about the triangle, that is a mutually reinforcing symbol, but this panel is also has been that in the transitional justice process in the Gambia. With me, I have the first panelist, who is Counsel Mariama Singate. She's a senior counsel at the Ministry of Justice, and she has also been a counsel at the Transitional Justice Truth, Reconciliation, and Reparation Commission in the Gambia. She's had extensive experience in criminal practice as well as transitional justice. And welcome, Madam Singare, or Senior Counsel, should I say. My second panelist is also Senior Counsel, Nene MC Cham, who is also the President of the Gambia Bar Association and also a chairperson of NALA, and has been also a former president of FLAG. She's been a gender and human rights advocate for a very long time, and she's also been critical in contributing to the transitional justice process in the Gambia. So welcome, Senior Counsel. We also have Mansour Job, who is the Director of Legal and Investigations at the National Human Rights Commission. He also was the Deputy Director of Research and Investigations at the TRRC, and he's also been a prosecutor at the Ministry of Justice. So another champion of transitional justice and human rights in the country. Welcome, Mansour. And then our final panelist is Madam Sirandao, who is the country director of ANECET. I'm sure when you talk about transitional justice in the Gambia, ANECET is at the fore of everybody's mind. She's been a key advocate of human rights violations. She's also she's the chairperson of the Association of the Alliance of Victim-Led Organizations, AVLO. And also seasoned activists in terms of human rights advocacy, in terms of social rights, transitional justice. So I welcome you all. Given the space of time, I would give perhaps 10 minutes to each of the panelists to give their remarks. But I also took it upon myself to perhaps make certain prompts based on my engagement with the communities and some of the stakeholders in the TJ space in the Gambia. One of the things, or my topic actually, or our topic here, is to discuss the SAM as a necessary mechanism to secure justice and accountability in the Gambia. And I've generally engaged with people on this, but one of the first things perhaps people would say is we have a DPP, we have a prosecution department at the Ministry of Justice, and this whole process is taking long, it's too complicated. Why is it necessary? So perhaps we can start with reflecting on the necessity. Why is the SAM? When I say SAM, I mean the Special Accountability Mechanism. Why is it a necessary instrument for achieving justice and accountability? Yes, please. Thank you.
Thank you very much, Mr. Dabo. I believe that the discussion on why started since morning. The Solicitor General, in his opening remarks, touched on that, and the Special Advisor, Ms. Person, also spoke on the why. But just to buttress on the issue, the why, if you look at the TRRC recommendation, specifically Compendium A, which highlighted the strategy for prosecution of cases emanating from the TRRC. The compendium provided several options for accountability, and the implementation plan actually derived some of its intervention in that area from Compendium A. And as highlighted by Ida, we did
consult on this particular area to see what is the best option for the Gambia. And as highlighted, Ida has mentioned that some of the crimes have internationalized elements that are not provided for under our legislations. Now, if we want to prosecute some of these offenses, we will have constitutional law challenges, because the Constitution does provide that no crime, no law. So we're stuck with that. And that is the same reason why Senegal, when they wanted to prosecute Habri took them to the ECOWAS court, stating that they want to prosecute him, but they cannot prosecute him under their regime because they do not have the law for that. So the ECOWAS court advised Senegal that in order to prosecute Habri, they need a specialized court, they need a hybrid court. So there's already an advisory opinion on that, that in order to ensure accountability for crimes that are not provided for in our legislations and crimes that have internationalized elements, we need a hybrid court. It is true that it has taken a bit of a time from the time the TRC submitted its report till now, but we need to understand that the framework was not there in the first place, and in order to ensure that things are done properly, we need to set up the framework first, and we are doing that, and we've done that. We spoke about the SAM and SPO's office. This is the start of it, and we're gradually working towards that. It's like a layer by layer of a brick. We've already started the foundation. Now we're building the house. And the house too will be costly. Building is costly. And we have to also consider that. We are also working on trying to get sponsors, trying to get funding for this process, and the government has already committed to also put in its resources towards the process. So there is already the political will to ensure accountability, but the framework is the one we are working on. I hope I've answered that.
Thank you very much. I'll just take a couple of minutes to perhaps repeat what you said in Wolof.
suba si liñ doore waxtaani special accountability mechanism mooy bunti aate bu ñoo jéem a taxawal pour ñi nga xam ne ñooñu la TRRC bi gisoon ne daal yaa nañ yele fi doomi aadama si réew mi nañ leen mun a isi taxawal leen si kanami luwa aate leen waxtaan boobu la ñoo continuer liñ nekk fii di waxtaanee nag mooy lu tax loolu am solo lu tax ñu war a taxawal beneen bunta fu mu nekk nii pour aate ñi nga xam ne TRRC bi gisoon na ne daal war nañoo jaar si kanami luwa soo li Mariama doon wax léegi nii rek mooy ne waa dëgg la ne am nañ ay bunti luwa si réew mi am nañ Ministry of Justice nga xam ne ñoom ñoo responsible pour aate ñoo xam ne xëj na dañ yaaxal luwa si réew mi waaye di nga gis ne am na yenn si réew moo gis bala ngaa mun a yóbbu nit pour aate ko si kanami luwa dafa fekk luwa boobu diñ taxawaloon
loo xam ne bokk na si luwaayi réew mi nga xam ne su ko nit yaaxee de dinañ la mun a isi kanami luwa bi waaye di nga gis ne yi fi xewoon jamono 1994 ba 2017 bi di nga gis ne am na yoo xam ne si yaaxa ak yële fi doomi aadama yi xewoon nekkut loo xam ne mu ngi woon si suñ luwaaye soo duñ mun a aatee nit si luwaaye Gambia rek si loolu soo loolu waral ba nga xam ne soo buggee def loolu fu mu nekk foog nga boole loxo ak international organisation yi comme ECOWAS wala African Union wala UN wala lu mu di doon daal si bunti mbootaay réew yi si àdduna si so looloo tax ñu taxawal loolu noonu yàgga na nag mu ne waaye lu tax tamit mu xala yàgga mooy ne bunta bu ees bu ñoo war a taxawal la te yëfi luwaa dafa am yoon yim dee war a jaar ndànka la dee dem dafa mel ni tabax néeg rek foog nga def foundation taxawal bloc yeeg yooyu bala nga am néeg bu taxaw waaye ñu ngi si process bi so si gàttal daal loolu la doon leeral léegi we will move to the second panelist who is senior counsel Nene Cham, president of the Gambia Bar Association as well, and know that the Bar Association has been very active in this process of, designing and, working on establishing and setting up these special accountability mechanisms. And I think one of the things that Ida said in her presentation was that it's always been said that it's going to be a Gambian court, but we need it to be an international court. So perhaps to help, reflect on that and what that entails, that this will be a Gambian court, but we need the international component of it.
Yes, thank you very much, Learned Council. Well, okay. We have seen that during the TRRC hearings, a lot of crimes were alleged to have been committed. Crimes, as Ms. Singate has just said, that are not in our books. So that necessitates a holistic look at what do we need, what mechanisms, what courts do we need to put in place to ensure that all the possible, or at least the most, serious of these crimes can be prosecuted and prosecuted effectively. So that is very important. It goes back to a question that was raised in the last session by a gentleman sitting here, saying, okay, why can't you get on with it now? You've already got, okay, fine, the special tribunal is not set up, but you've already got the special criminal division. And the answer to that is that the special prosecutor's office is not yet equipped to deal with that. So that's, I just wanted to also say that. Now, in terms of Gambianization, it's very important because otherwise you cannot get the buy-in of the public. They're like, okay, this is all done outside with internationalized crimes, international experts, international ECOWAS, it's all out there. But it's important, as Ida has highlighted, to note that we have been involved from the beginning. And it's crucial that it is a Gambian, seen to be mainly, Gambian-owned process. We have enough experts. Even when we say international, we have enough Gambians who are working out there, who are specialized in in this field, who can come back and man these positions. It gives more confidence, I believe, to the victims, and it gives us the ownership that we really do need, so that we are seen to be participating in our own affairs and dictating, because I think if even for the alleged perpetrators, they would have more confidence in the system if they see themselves being tried and defended mainly by the Gambians. So that also is very important. But the establishment of the Special Criminal Division, which I really wanted to point out, depends solely, and I think as soon as that office, the prosecutor is appointed with his or her staff, I think there's nothing stopping prosecution from beginning pending the establishment of the tribunal. I wanted to add a bit more about, but it's okay. Fine, yes. All right. Yes. On one reason, paramount reason why it's so necessary is a lot of offenses have seemed to have been committed here, and sorry, I've just lost this. I had made a note so that I don't forget, because when you ask me questions, then they're outside what I've already wanted to also say. Yeah. Yes, so the whole process, what does it do? It ensures that justice prevails. We live in a rule of law country. It is in everybody's interest that this process is begun and seen through, just like any other alleged crime that has been committed. If somebody is robbed in the streets, you expect the police to arrest the person, investigate and prosecute.
If murder, likewise. So it is very important. I mean, I say this because a lot of people say we should leave bygones be bygones and just move on and forget and forgive. It's absolutely necessary that we do this in order to be able to move on. That way the victims have justice and the rule of law is upheld. And there's all sorts of reasons, other reasons, for example, like deterrent effect, so that other people never again will we live in a Gambia when people can just commit such crimes and get away with them. So a strong message needs to be sent that impunity really is not an option. That's just what I wanted to add, sir.
Thank you very much, Madam President. So na bamtuwaat rek li mu waxoon tamit si wolof si lu gaaw li ñu doon waxtaanee moom mooy ne comme li ma ko doon laaj mooy Aida bi moo wax fii wax na ne code bi ñoo taxawal ni mooy special accountability mechanism bi nañ ne hybrid code la which means ne dina am international component waaye soo ko seetee kooti Gambia la ba léegi loolu laa ko doon laaj mu faram-fàcce ko tuuti so mu ne doore na ko nag soo xoolee tamit am na ku fi laajte woon ne lu tax
parce que special accountability mechanism soo ko xoolee mu ngi am beneen bunta boo xam ne boobu si kooti Gambia bi la bokka mooy special tribunal bi nga xam ne Chief Justice bi taxawal na ko mu ne nag am na ki doon laajte lu tax kon ñi jàppa already dooraguñ di leen aate si bunta boobu noonu comme que boobu si biir réew mi la nekk mu ne soo gisee loolu am mooy ne Special Prosecutors Office bi mooy bunta bi ñu war a ubbi tamit pour mu amee ñi nga xam ne ñoom ñoo war a comme isi case si code boobu noonu boobu bunta boobu lañ taxawalagut ñu ngi recruit comme ñu ngi ut ñi fa war a nekka mooy ne Gambia am nañ xam-xam bi am nañ kàttan bi pour def li ñu war a def pour aga dox lii ñun ñoo toog seet lan lañ soxla lan lañ bugga ñun ñoo ko designal suñ boppa ba pare suñ ñëwee si taxawal ko tamit xam-xam biñ am biir réew mi ak si bitim réew yëpp dinañ ko mun a boole ba nga xam ne Gambia ñoo see gën a uppa doole si liggéey bi daal waaye tamit taxut ne soxla nañ international component boobu noonu lim ko tëjee nag mooy mu ne soo gisee am na ñoo xam ne xëy na dañ dee wax ne sax yii yëpp coono la rek nañ leen fàtte li fi xewoon ñu continuer dunda suñ dundeen ñun yëpp ñu nekk si jaama rek MC mu ne loolu soo gisee nag mu am solo mooy ne soo gisee society ñun yëpp ñu bokk ko kuñ si tooñ war nga am tamit foo mun a dem ñu fajal la sa naxar soo di nga gis ne victimes si deserve nañ justice boobu noonu ne tooñoon nañ leen war nañ leen a jox seen digga waaye tam mu ne di nga gis ne tamit réew du mun a nekk ne rek ku nekk loo def rek ñu bàyyi ñu mu jaala wala ñu seet si yàlla rek bàyyi la nga dem parce que loolu tamit soo gisee ñuy dee aate mooy pour ñu make sure ne nit yi nañ si jàngee ba nga xam ne duñ defaat yooyu nga xam ne ay yaaxa yu fi amoon la so dinaa move to third panelist bi again for the sake of time but Mr. Mansour gis naa yaa ngi take note so I will just allow you perhaps to make a general reflection on the discussion so far and what you think of the sum within the context of the topic, which is that it's a necessity, it's a necessary mechanism for justice and accountability.
Yeah, thank you very much, Imran, and thank you to my co-panelists. I would like to use this opportunity to thank Ictj and the Ministry of Justice for organizing this dialogue. First, I would like to begin on the issue of why is it necessary to have these mechanisms in place to address past human rights violations. Even though the previous speakers and Mariama Singate has provided some reasons as to why we should have these mechanisms, that is the International Criminal Tribunal, the International Criminal Division of the High Court, and also the Office of the Special Prosecutor. We have to bear in mind that following the 2016 presidential election, there was an aspiration from the Gambian people to have an accurate historical record of the violations that were perpetuated from July 94 to January 2017. And that is what the TRRC started. And because we are in a transitional justice process, the process will not be complete if we are unable to have criminal accountability. Bearing in mind that one of the reasons for the establishment of the TRRC was also for the recommendation of people
who bear the greatest responsibility of this violation. And as most of them has mentioned, the reason why we need to have an internationalized tribunal is to cater for the offenses that are unknown to Gambian law. And this is particularly important because we are told that whenever a wrong is committed, there has to be a remedy for that particular wrong. If my learned senior, the late Dr. Carroll, was here, he will translate that into Latin. But we need the International Criminal Tribunal because that will be a true representation and reflection of the actual crimes that were perpetuated. Some people will say, okay, if someone commits the offense of torture or enforced disappearance and murder, the person will not get a punishment beyond life imprisonment or a death sentence. So why would you need the International Criminal Tribunal when you can achieve the same objective from the International Criminal Division of the High Court? But the difference is the magnitude of the offense that was committed, and also to ensure that this historical record is being validated by the court. So I think that is very, very important that we have the Special Criminal Division as well as the Special Tribunal to cater for those kind of offenses. But in the prosecution of these offenses, this was also highlighted by the first speaker, that is the prioritization of crimes that will be prosecuted. And I believe we do not have the competence to comment on this, but the special prosecutor will do when he or she eventually comes into office. However, one important thing to factor in this process is the involvement of victims or the victim participation in order to be able to mitigate against the expectations of the victims. Because obviously in the prioritization of cases, the special prosecutor has to be convinced by the strength of the evidence that is available to him or her, and that is why there is the need for further investigation into the records produced by the TRRC. Importantly, in that regard, is to maybe have a prosecutorial guideline that will be developed in a very transparent manner that will also involve the participation of the victims, so that victims are very clear from the beginning about the process and procedure for the criteria that will be used for the identification of cases that will be prosecuted before the tribunal, but also before the Special Criminal Division of the High Court. So I think these are engagements that should be done from the beginning once the office of the Special Prosecutor is up and running. In terms of respecting the rights of accused person is also part of victims' expectation. We have to manage their expectation. The TRRC was very much victim-centered, but in criminal prosecution, respecting the rights of the accused person is entrenched under our constitution, meaning that every accused person has to be presumed innocent until the contrary is established. And this means that the accused persons have to be protected, they have to be availed with all the evidence that is going to be used against them, and even if they are unable to provide counsel for themselves, they need to be provided one by the state. So you will see some resources would have to be allocated for that, and this has to be also respected, because it's important that if we are calling to have a country for the rule of law, that we also respect the rights of accused persons in the entire process. So it's also important that when the Office of the Special Prosecutor is up and running, that there is a prosecutorial guideline, because this will also assist and shape the direction of the prosecution of these cases. These two, I believe, should be done with the involvement and participation of the victims, so that they are not left behind. So in essence, this is what I wanted to speak about as far as the need for the establishment of the Special Criminal Division and the Special Hybrid or Special Criminal Court is concerned, as well as the establishment of the Special Prosecutor's Office. Finally, just on victim participation is very important. Most of the victims or witnesses that testified before the Truth, Reconciliation and Reparation Commission were not confronted with much challenges. And what I mean by this, their evidence was not challenged, they were not subjected to cross-examination. But this will be done during the criminal process, during the criminal accountability process. So this is something that the victims and witnesses must also be prepared for, to know that they will be challenged by accused persons through their lawyers in the entire process. So to conclude, I will just want to indicate that criminal accountability will ultimately strengthen the integrity and legitimacy of our criminal justice system, and therefore we must remember that accountability is a cornerstone to maintaining the rule of law in the country, and therefore this is something that is welcomed by everyone to ensure that perpetrators of human rights violations are accountable. So this is one way that we are able to sustain the TRRC Never Again mantra. Thank you very much.
Thank you very much. Those great reflections from Mr. Mansour. So dina bamtuwaat li ma laajoon Mansour rek moom it moo nekkoon ne moom amaluma ko benn laajte xëj na waaye maa ngi ko gisoon mi ngi jël nu sa mis foofu ma ne ko ndax dina mun a waxtaan rek si luy xalaatam si mbiri special accountability mechanism bi. moom nag li mu wax mooy comme li
ñeneen ñi doore rek mooy ne am solo gi moom boobu amut wedi wante sax ne special accountability mechanism bi am na solo trop because soo ko seetee mu ne bi nguur gi wéccee ko 2016 2017 réew mi yëpp liñ bëggoon a xam mooy lana fi xewoon su ko defee suñ xamee lana fi xewoon beneen liggéey biñ sasoon TRRC bi mooy ne ñu make sure ne ñoo xam ne ñoo responsible woon pour li fi xewoon ñu aate leen so mu ne liggéey bi ñuy wax ni mooy special accountability mechanism bi continuer la rek liggéey TRRC bi du mun a jekkale ko mukk fekk ne accountability court process bi tamit bokkul si liggéey boobu noonu waaye mu ne tamit xëy na di nga gis ne léegi-léegi ñu xalaat ne waaw am na yoo xam ne sax mun nañ koo aate fii nii soo lu waral ba hybrid court bi war a ñëw tamit soo li moo wane mooy ne am na xëj na sax yoo xam ne munoon nañ koo aate fii tamit tëj boromam parce que soo tëjee borom soo ko aatee crime boo xam ne mu ngi si luwaay réew mi liñ koo tëj ak liñ koo tëj si international court bi xëj na li utee du bari waaye mu ne dafa am solo tamit pour international court bi parce que liñ la tuumaal ne loolu nga def tamit APA bi dafa important pour ñu xam ne lii lu garaaw la lu doy waar moo xewoon si réew mi so torture for example mun ngaa yóbbu nit si réew mi fii aate ko ne dafa dóor nit wala dafa attaque nit wala dafa toroxal nit waaye du eegut level boo xam ne xëj na di nga ne torture foofu la eega so loolu tam dafa am solo mu ne pour ñu understand ne li fi xewoon dafa jéggi dayoo te warut a amaat waaye bu mu paasee loolu tam am na yenn mbir yoo xam ne mu ne war nañ ko sóoraale si process bi mooy ne ñu ngi fi waxtaanee yenn mooy ne special prosecutors office bi mooy ki war a amee yëfi isi case yi si court si moom si boppam mooy war a seet ban case o yan case la foog ne ñoo gën a am solo pour yóbbu si bunti luwa woo mooy court bi waaye kooku ni moo xoolee mooy nekk ban façon ngi evidence la am nag case ami naka la ko mun a prouver si kanami court bi looloo koo gën a itteel parce que liggéey bi loolu la laajte waaye léegi-léegi dina fekk ne xëj na loolu tamit dina utee ak victime si seen boppa liñ bugga soo su ko defee mu ne dañ war a sóoraale ne kon dañ war a make sure depuis si doorin bi pour ñu waxtaan ak victime si ba nga xam ne understand nañ lu tax diw wala special prosecutor bi nii la nekk di doxalee parce que lii la liggéeyam laajte soo gisee xëj na jëlut case bi wala isi wut case bi nekkut ne dafa xaajaatle wala dafa génnaatle waaye dafa fekk ne liggéeyam bi loolu la doole boobu la ko jox wala loolu la ko won ne moo gën a possible daal beneen bi mu wax mooy ne dinañ war a tam sóoraale even victimes yi pour dimbale leen pour ñoom ñu sóoraale ne liggéey court bi daf tey important pour ki nga xam ne moom lañ tuumaal ne moo def yaaxa yi tamit ne moom it foog ñu jox ko su fekkee ne for exemple dañ tuumaal nit ne dafa reyoon fii nit waaye amut ku ko taxawal si court bi comme lawyer bu ko dimbale si keesam bi foog ñu utal ko loolu noonu foog tamit liñ ko tuumaal yëpp foog ñu fexe ba information boobu noonu yëpp mu jot si pour su ko defee moom it mu mun a taxaw mun a defend boppam su fekkee ne am na li moo defendee boppam yooyu noonu ak tamit li mu mujjee wax mooy victim preparation mooy ne victime si tamit comme TRRC bi danga dee ñëw nga wax nga dem waaye su ñëwee si mbiri court loolu duy am si court bi di nga gis ne su victime ñëwee wax ne lii ak lii la ma diw def diw boobu noonu tamit right am mooy ne moom tamit war naa mun a ñëwaat jubluwanteeg victime boobu wala at least looyaam ñëw jubluwanteeg victime boobu noonu pour jéem koo laajtewaat pour leeral ne déedéet du man maa defoon lii xëy na da nga juum wala demeewut noonu loolu nag daf dee mën a métti si victime si soo mu ne yooyu yëpp dañ ko war a sóoraale fu mu nekk nii xamal ko victime si pour ñu xam ne dinañ am pour jànkuwanteel façon challenges yooyu noonu si process bi foog naa foofu la mën a yem si translation bi then léegi naa move on to the final panelist mooy Antisira Antisira you know this we saying that the SAM is necessary but even as a necessary mechanism we also want to make sure that it is effective it serves its purpose and it is still within the context of transitional justice that we are establishing some of these mechanisms. And that means inclusivity, participation is always a key part of that process. Considering though this setting up of special mechanisms, you find that it's very much a legal process, and that becomes a challenge for non-legal, non-state entities to participate. So what are your reflections on that in terms of our process?
Thank you very much, Imran. I just know that you have senior counsel and two senior counsels, Mr. Mansur and then Antisira. But I'll take that. And the Auntie, I'll take that. Thank you. Yes, the legal aspect of it, especially when it comes to the participation of victims, which Mansour has highlighted, and which I'm sure that everybody cannot overemphasize. You cannot have this process being successful without the participation of the victims at all levels.
Whether it's from the engagement, like this engagement, and even in the courtroom, the witnesses, most of them we would expect to be victims. So really, that is very important. So in that context, really, for me, given that it's such a technical process, and we are also all struggling, from civil society ourselves, even the organizations trying to get this out. It's really important that we really break this down and make it in a way that the victims understand. I think one of them, which we are doing a great job at, by the way, which is the translation, really understanding the local languages, speaking to them in the language, speaking to us in the local language, in the language that we understand, and in a manner that we understand, right? So that is very important. So for me, I really want that to be the driver, having victims being engaged in context of how they understand, and also really putting the transitional justice in context. And I think that is what the SAM is about as well. The SAM brings accountability to our context. We are capturing our reality with the SAM. Lack of resources, how do we address that? We don't have lack of resources, lack of the laws. We don't have the laws to address. So the SAM really is also capturing our context, to making sure that it makes provision where we have an opportunity to where we are partnering with an international body that will bring us the laws that we need to prosecute some of the crimes that we have committed and some of the perpetrators. Yes, we have our local courts. The other context is our reality is also the magnitude of there's this number of crimes that we have committed. And like Anna Maria mentioned, there's no country that really can handle transitional justice. When you have widespread serious human rights violation, no country can handle it, no matter how many resources you have. There has to be a special process. And if you look at our Gambia here, we see here, this is one of the reasons I think why people, when they catch thieves in their homes, they beat them to pulp and then let them go. It's because our system cannot handle it. You take the thief to the police, there's so many, police stations are overcrowded, they're overloaded. Our prisons are overloaded. Our judicial system is overloaded. One of the reasons why people don't go to court is because it takes so long. Imagine if we have to add these cases to our current normal process. It will never happen. It will take forever. So that is really one of the reasons why we have to have this, and important for victims to understand that and are supporting this process to make sure that they get the justice. Somebody mentioned earlier in the conversation that victims are dying. If we want to wait for a normal process, it's going to be taking us a long time.
And also memory is fading, not just dying, but memories are fading as well. People's memories are fading. Even the TRRC, some people were struggling to get the stories right. Imagine you are facing a defense lawyer protecting the interest of his client or their client, and you're being cross-examined. It's not going to hold up in court. So that is why it's important to have that special process that is on the side where we dedicate resources to it and are able to move the agenda of justice and accountability forward, which every victims need. And this country need, not just for this establishment of rule of law, but for development and for peace and stability. These are all things that is very important. So for me, really, it's all about, for us to think about it in context or just simplify it. This process is about consequences. Nature, the rule of nature, law of nature demands consequences for everything that you do. Whether it is good or bad, there are consequences. If you cut a tree, you're cutting down our oxygen supply. If you plant trees, you're increasing our oxygen supply. If you do good, you are rewarded. That's why we have awards and certificates and you graduate university, you have the certificate, you get a job. If you do bad also, there must be consequences as well. So this accountability is all about consequences that needs to happen. Then is mentioned again, we have a constitution. We're a country of rule of law. Our law demands that if somebody does something wrong, they're held accountable. Whether the individual forgives or not, we are a country, we are a people. The state has a responsibility to protect and promote, protect the rights of people and also promote people's rights. The other aspect that I really want to end with, in conclusion, is to bring it home. And this is something that I borrowed from one of our sessions that we had with the victims earlier in the year, where they tried to explain really how why we need the internationalized tribunal. So they equated it to using the football as the setup. Where you have the Gambia, we participate in matches. We have our national matches. The national match, that is our domestic court. We can play it here and do everything here. We have all the rules we need for the domestic courts to play, so national matches. But when we have international matches, we don't have a standard stadium. So we have to go out of the Gambia. We have to go out of the Gambia. It is not mine. I borrowed it from somebody and I have permission to use it. Trust me, I am not that big of a football fan. So we don't have a standard stadium. So when we want to play our international matches, we go to Senegal, or we go to Ghana, Uganda, or we can go to Belgium. Naturally, if we are to save money, the closest place is to Senegal, right? And that is ECOWAS. Uganda is AU, Belgium is the UN. So it is natural that when we want to play, we need the ECOWAS to go there. So really, that is really why we need this internationalized laws. We don't have the stadium. We need to play the game to win the match. Thank you very much.
Thank you very much. This year. Foog naa dinaa just baamtuwaat boobu tamit su ko defee ñu mun a waaye waxtaan na fi waxtaan bu am solo li ma doon laajte rek mooy ne ñu ngi wax yëfi court ñu ngi wax yëfi special accountability mechanism waaye soo ko seetloo liggéey boo xam ne la li ko fa doole yëpp yëfi luwaa la de la
amal affaire soo gisee liggéey transitional justice lu tax mu gën a am solo si réew yu mel ni Gambia mooy ne ñiñ tooñoon dañ war a bokk si mbir mi dañ si war a am baat so maa ngi ko doon laaj pour mu just xëj na seet ñun su suñ contexte bi fii nii ban façon ngi baat ban façon ngi rôle la victime si ak organisation yi dimbale victime si yan façon ngi rôle lañ mun a am si liggéey boobu noonu so lim doon waxtaane mooy ne nag réew mi soo ko gisee process bi waa dégg la ne legal process la yooni luwaa yëfi luwaa la waaye mu ne dañ ko war a wàcce yombal ko pour ñi nga xam ne ñoo gën a tax ba mbir mi yëpp taxaw because suñ tooñutoon kenn si réew mi duñ doon am transitional justice process so dañ war a break down wala dañ war a faram-fàcce waxtaani liggéey bi ba nga xam ne ñi si am ité boobu noonu ak ñi tooñoon dinañ mun a xam lana nekk di dem loolu nag mu ngay wax ne ñëw na si yëfi laaka ne dañ dee war a mun a xëj na suñ amee waxtaan yi nii mun a yombal mbir mi pour wax ko si laaka boo xam ne xëj na victimes yi dinañ ko understand dinañ si mun a bokk tamit waaye mu doon wax tamit ne soo ko seetee ñun suñoo wax yi fi ne dañ ko war a histoire su suñ contexte tamit mooy ne foog ñu sóoraale ne lii liggéey boo xam ne la tamit dafa laajte dépense dépense bi nag bari na façon xëj na even kees yi ñu war a am rek pour isi si yooni loi bi bari na bari boo xam ne suñ waree toog di xaar pour loolu jaar si code bi ñu am fii nii dina yaaga lool so loolu yëpp waral na ba nga xam ne special accountability mechanism bi loo xam ne la soxla nañ ko waaye tam mu ngi wax ne soo ko seetloo war nañu sóoraale tamit ne victimes yi foog ñu dimbale leen si process bi pour mu am njëriñ parce que soo ko seetloo victimes yu bari ñu ngi mag ñu bari ñu ngi ñàkk seen bakkan bi ko xëj na wérgu yaram ak yooyu noonu mu ngi manqué di nga gis tamit ne ñoo bari ñu ngi fàtte fu mu nekk nii li xewoon parce que bi moo xew yàgg na soo ñooñu yëpp mun nga leen a ñëw isi sax ba si biir code ñu ne la fàtte naa li xewoon soo mu ne yooyu noonu yëpp mbir yoo xam ne la foog ñu sóoraale ko su fekkee ne mécanisme yi ñoo bugg a taxawal nii dina am njëriñ biñ séentu oo biñ bugg a si moom foog ñu make sure ne yooyu noonu yëpp sóoraale nañ ko naka la ñoo dimbalee victimes yi nii ba nga xam ne dinañ mun a fekkee ak bokka si liggéey boobu noonu ñoom tamit mu ne nag liggéey bi nekkut na sax mbir yi fi aate rek la ak yooyu noonu waaye soo gisee ñuy taxawal bunti aateekaay si société bi mooy ne dina yokka tamit ne respect loi bi fi waroon a am te mu ñàkkoon fi jamono yooyu noonu suñ defee process yi daf dee mun a gën a dëgëral yooyu noonu ba pare tamit dina mun a gën a isi jàmm parce que ku nekk di nga seetaat sa bopp bala ngaa def yenn yi pour ne dinañ ma war a mun a indi si bunti loi so si gàttal yooyu la doon yooyu la reflect on moom tamit so that concludes the panel so for the interest of time again because we were reminded that it's Friday so perhaps I can go back to I was going to ask if the panelists had other reflections but I feel in these situations it's also ideal to have the comments of the participants and so perhaps we can open it up and ask if anybody has comments or questions for the panelists. Thank you.
We can have two because of time. Thank you.
Thank you very much. I'm Mr. Sirikan from Ministry of Defense. I thank the panelists for that wonderful deliberation. Obviously, I think they have hit the nail on the head. They at least sort of orient people about what actually is happening. And before I go further, I think I will thank Minister of Justice and also either person and the team for the wonderful job that they are doing, which I'm actually aware of. That obviously all what have been said here are actually things that actually are happening. But obviously it's also important that we have these type of forums, stakeholder consultations, town hall meetings, focused group discussions. This actually make people to understand what is happening. Because like to many people, the process is very slow. And then why are they thinking in that line is because of the fact that they are not feeling the impact as of now, what actually is happening. But like the issue of having such engagement will make them understand what actually is happening. Like you cannot start such process just haphazardly. We have to first put in place structures that actually will facilitate the implementation of these recommendations. And those structures have to include legal frameworks. These things are very much legal. So obviously you have to have legal frameworks, and you also have to have structures in place that will support the implementation of these recommendations. It has been said here many times by almost all the speakers that everything starts gradually. You cannot just jump into anything and then just conclude it. We have to start it gradually. But this gradual start of things must be sort of communicated to people. This is why the TRRC unit under the Ministry of Justice ensures that there is communication strategy so that people will be aware of what actually is happening, and they also will know that obviously something is happening. I obviously am very much pleased that comparatively with other reforms that are happening in the country, TRRC is becoming #1 that people are becoming aware of, but because of their engagement with the public and with the people. So it is important that we all recognize what actually is happening. Rome is not built in a day. So obviously it has to be gradual. This is why in some of the discussion we said that we need to start with low-hanging fruits first, so that at least people can feel the impact of what is happening. So it is important that all those who are obviously representing their colleagues, because not everybody can come here, but like you are a representative. Some of them are representing their families, others are representing some institutions. So when you go back, we tell them what actually has transpired here. What are the discussions that have taken place? So they will also have the knowledge of what actually is happening as regards the TRRC, implementation of the TRRC recommendations. That said, I have a question of with regards to the issue of the prosecution. We all know that a lot of victims, obviously, actually have died, before getting justice. And these are people who actually, the family probably may feel that their loved ones have not received any justice. And I just want to find out what are some of the strategies put in place to ensure that even though those people have passed out, they have died, would they not still have justice? Because they have families behind who actually are still feeling the pain. So that's a question that I want to ask. And then one of the first speaker spoke about the issue of witness protection. I think all those are legal frameworks that actually are put in place because the Human Rights Commission obviously formulated a policy on victim protection. I think Martin was the one who led that. I think those are some of the things that actually we have discussed. So thank you very much.
We'll only have him, and then you answer the question, we wrap up. Thank you.
All right. So any questions?
So I just want to respond to the question of the victims that died, whether they will have justice. It has been alluded by previous speakers that the special prosecutor will be the one responsible for deciding which cases to prosecute. And if there is evidence, sufficient evidence for the special prosecutor to proceed with a case in respect of a victim or group of victims, he will do so. So it's all on the special prosecutor to decide which cases to prosecute. But the TRRC
records are available and they're already there. That would be a starting point for the special prosecutor. But the TRRC process also did not follow the due course as to investigations in
accordance with our laid down procedures. It was a truth-seeking process. It was not an accountability process. So the special prosecutor will have to reinvestigate all of those cases and then prepare his own case file and docket for prosecution. Thank you.
Thank you very much, Ms. Singate. I think we will conclude with that, given the time constraint. But I'll just perhaps repeat your answer also in Wolof. Mbokk yi lim Mariama laajte bi moo nekkoon ne am na comme ni waxtaankat yi waxee fii ne am na victimes yoo xam ne ñaatañ seen bakkan te fekk jotaguñ justice wala aate yi biñ doon expect gisuñ ko fekkee wuñ ko. mu ne ndax ñooñu noonu nag dinañ am justice ba léegi loolu la Singate doon tontu ni soo lim nekk di wax mooy ne soo gisee liggéeyu TRRC bi defoon na ko gëstu nañ am na information bu TRRC bi boole mu ngi tegu boobu ba léegi loo xam ne la nit mun na see wéeru waaye su ñëwee si yooni aate ak yooni court loi dina nekk ne loolu nekkut information wala xëy na xibaar boo xam ne rek court bi dina si mun a wéeru waaye mu ne special prosecutor's office bii nii prosecutor bi su ñëwee moom si boppam dina am pour gestuwaat cases yi xew nii yëpp soo kooku mooy war a determine moom mooy war a seet yan façon yi case ñoo war a mun a ñëw si court bi based on lim xam ak xëy na gestuwaat yi ñoo bugg a gestuwaat lu mu si jëlee den foofu laa mun a nag décider naka la yan case ñoo war a mun a ñëw si court bi so xëy na suñu eggee si ok so senior counsel fa bugg a xëy na joxe another response ok so that was the conclusion loolu la woon rek loolu la doon jéem a leeral rek waaye xëy na lu ma bëgg a yokk si loolu rek mooy nekk ne xëy na dinañ am justice si beneen boor tamit because justice bi amul tamit rek si accountability dafa nekk ne tey accountability lañ nekk di waxtaane waaye façon victims yooyu noonu ba léegi seen family si mun nañoo am benefits from reparation programme bi ak yeneen mécanisme si transitional justice bi waaye su ñëwee si accountability boobu prosecutor bi si boppam mooy gestu ba seet ba yan case la moo yóbbu si kanami court bi senior counsel.
Yes, I just wanted to acknowledge the support received by the Gambia Bar Association in its collaboration with the Ministry of Justice. I saw the Deputy British High Commission was here, British High Commissioner, but he's left. I spoke about the establishment of the Special Criminal Division. So the structure is not there. So with support from the British High Commission, the judiciary is actually renovating, they've identified a place, renovating the premises where the court will be housed, so that then they can begin working. So I wanted to acknowledge the support of the British High Commission and also the USAID through Democracy International. I see Ngone here, supporting the work of the ECOWAS Gambia Joint Technical Committee, and also the Special Prosecutor's Office, the establishment of it. So thank you very much.
Thank you very much.
Thank you. Should I say it in Wolof?
I think it's fine. That's fine.
Okay, so it's just a short one. So
Yes.
we don't def mooy daf doon wax tamit ne am na organisation yi fi nekk ñoo xam ne yàgg nañoo dimbale Gambia si process bi. moo wax mooy comme special tribunal bi ñoo wax nii ne bokk na si special accountability mechanism bi ne taxawal nañ ko waaye place pour fi moo nekk bunta boobu noonu am na organisation yu fi nekkoon ñoo xam ne ñoo nekk di dimbale Gambia Bar Association ak government bi pour ñu rénover pour ñu defaraat place yooyu nga xam ne court boobu noonu foofu la moo amee foofu la moo taxaw foofu la moo nekk daal so yooyu la doon wax am na yeneen bunta tamit yu fi nekk di dimbale si liggéey bi ñëpp la doon wax jërëjëf rek si gàttal loolu la woon maa ngi leen di wax jërëjëf thank you very much everyone.
Thank you, Mr. Imran Dabo, for this wonderful session that you held. Actually, it's the final and session. Apologies, we're running out of time, but we will soon wrap up. This other phase of a panel discussion is on establishment of the special tribunal challenges and opportunities. And we'll be having the ASP, Kalyu Kinte, GPF, ASP Luke Jata, GPS, and the Judiciary. And this will be moderated by Aisha Jame. Put your hands together as they come up. And then we have, please, the questions and answers or the question sessions, please let's make it very short as you're asking your question. Go straight to the point. As I said, I'm not joking with the time. Thank you. Thank you. Thank you very much. And I now hand over to Madam Aisha Jame for this session. Thank you.
Thank you very much, Amanda, and thank you, Imran, for that presentation, and to your panelists, they were all great. My name is Ictj. I work with the Gambia Center for Victims of Human Rights Violations, but I'm here because of Ictj. Since I am on leave, but I had to just
come and honor this invitation. I have my wonderful panelists here. I would just go through a short introduction. So, Miss Fatma Tal is here to represent NALA. Mr. Alojalo couldn't make it, so Fatma is here to step in for Alif. And we also have Mr. Luke Jatta on the table from the Gambia Prisons Department. Luke Jatta serves as the Public Relations Officer for the Office of the Gambia Prison Service, where he is responsible for communications and outreach. In his role, Jatta works to promote transparency within prison system and provide accurate information to the public regarding the operations of the prisons policies of the Gambia. His work also includes building public trust and ensuring the Gambia Prison Service aligns with human rights standards in the Gambia. Welcome on the panel, Mr. Luke. And on my far left, we have Mr. ASP Khalilu Kinte, who works at the Gambia Police Force. Mr. Kinte worked at the prosecutor unit and as well in charge of prosecutions unit at Brusubi Police Station. He obtained an LLB at the University of the Gambia and a BH at the Gambia Law School. Welcome on the panel. Yes, so today our discussions would be basically the establishment of the special accountability mechanism process. It's mainly on the challenges and opportunities for the the accountability mechanism process. And I'll start with Ms. Fatma Tal. What do you think are the challenges for setting up of the special tribunal, the special accountability mechanism process? Yes. Yeah. Thank you.
Thank you very much, Aisha. One of the challenges, I think, would be
funding. I think adequate funding is part of everything that you want to set up, mostly something as important as the tribunal. Also resources allocation as well. Another challenge will be political will?
Yes. It requires the commitment of the government 100% to have something, you know, to set up something as important as the tribunal. Yes, so.
Thank you very much, Ms. Dahl. I think mainly, most of the time, these are the challenges that we do have when it comes to implementing some of these recommendations that we had on the TRC. And of course, I would agree with you that funding is a major challenge that we have in the process. And oftentimes, we always talk about the lack of political will from government. And this is things that we always hear in our platforms, that people feel government don't have the political will to implement the accountability mechanism process. And these, I would agree with you, sometimes victims would even say these things in most of our sessions. But with currently all the things that are happening, I think you would agree with me that government have the political will to ensure there is accountability process in the Gambia, because of the efforts that you're doing, trying to set up the special tribunal involving all CSO actors, especially the AVLO. I think there is a political will from government, if you would agree with me. Thank you.
Yes, so
Mr. Luke, the same question I would like you to also speak a little bit on. But then maybe you can speak more around the opportunities for setting up of the special tribunal. Thank you.
Thank you so much, Ida, for that wonderful question. If you look at the Gambia Prison Service, we are service providers. I have mostly, that's what I allude. And
in providing services, we have to look at services that are very optimal and also which has to in compliance with human rights. Because if you look at the prison itself, and we deal with all kind of spectrum of people within our environment, those that are mentally challenged, disabled, and even that are also in conflict with the law. So I believe when the tribunal is set up, it will also help to improve some of the service. Now we have one of the services that we think is important is the infrastructure. We've seen that the Gambia Prison Service, even the TRRC recommendations, that the Gambia Prison Service, if you look at the structure, these are colonial buildings. How do we fuse the structures that will also be in compliance with international standards? How are they designed? Are they human rights friendly? Are they conducive for the environment at which the people that are living in? Because if you look at even, let's say for example, from the recommendation we saw 44, the recommendation that these people will be prosecuted. What happened if they are remanded? Are they remand capable to make sure that it conforms to the best practices when it comes to human dignity? Because that's one of the most important that we do, because we want to accord every human being that human dignity, which is in conform to the human rights that we're talking about. One, we want to make sure that even where they live, the conditions, are they up to that standards? So I think all these things are geared towards having a concerted effort so that we protect those people. Not only that, also by virtue of what we do. Do we have programs? Let's say if they are also convicted, is it the normal tradition programs that we are giving there? Let's say, for example, 20 out of those that are convicted are people who are highly educated. What are some of the programs that we bring in board so that they also feel that they are also in a community, not only incarcerated, not only in prison, but they also have another life that will also give them a befitting stay while they are serving their sentence. Because we also look at the security aspect of it. Because if you look at also because this is a special adventure that we are into, if the traditional security is that we are none of, because now we are looking at what is the conception of people outside there? Will people be very receptive to what we do? Would they also acknowledge that, okay, these are people because, of course, of the crimes that they have committed, genocide, or any other forms of crimes that are international in nature? will the people be happy with them? If not, how do you protect them? All these are mechanisms that we have to look, because it also improves some of the services that we do, except when it comes to security. Like, let's say, for example, we have the riot unit, which is to make sure that it's a protective method that has also been in line with the police, so that we also be accorded with the materials, with instruments, and even the riot unit gadgets that we needed. Mobility, I think it also helped to boost that, because then entirely what will be designated, let's say for example, vehicles that are used for protective. When all those vehicles are put in place, it also helps to make access mobility, so that it will be very, very concerned, because these are people that we need to give them that attention that is needed. And also it's also improving some of the, the human security, the well-being, because it also helps to improve some of the services that we do. Let's say, for example, in as much as a number of people are also coming, even let's look at the food security, because it's also part of it. If the Gambian government is allocating, let's say, on monthly basis, 2 million, now we're seeing extra, because if you look at even the prisons now, there's mass influx on daily basis. Okay, so now that will also help to add value even to the budget that is allocated, because we believe that a balanced diet, adequate food is also important, so that we're able to give these people that service that we need. Because in as much as we are an entity, a law enforcement entity, we also want to protect, to make sure that food is adequate. And also let's look at giving them that access to the rule of law. Now, in the Gambia Prison Service, we also happy to announce that we have the paralegal unit there. And this paralegal unit is just a newly formed unit. Of course, some of them might need our services. We might not represent you in court, but I think we can draft all legal instruments within to also support you, if that is doable. Because now we understand that these are also international crime. Not only that, maybe the government will also say, okay, through the Ictj, that let's also, so that they accorded the rule of fair trial, that they also have lawyers who are there, that they can also employ, because they also have that right. Sure. So given that right, that will also help to boost that, the legal service that we also provided, because I believe it's also in concerted effort, so that these people are also given accord the rule of law, and also the rulers say that give them fair trial that they also needed. Because I believe if this is also set up, it also help even capacity building, because as officers we also need capacity building on how we handle these people. Because it's very, very important, in as much as we are giving them security, because security is number one priority that we give, so that they are protected from any form of harm or violence that could be meted to, because we are also looking at any unforeseen circumstances, so which we also are very, very keen to prepare. And I believe if those measures are put in place, it will together boost the service that we do. Thank you.
Thank you very much, Mr. Jata. I think you could not have said it any better, because what you've brought in is the broader institutional reforms of the accountability process. You talked about the rights of prisoners. You talked about you as prison officers as well need capacity. And I think the accountability mechanism process would definitely go into those areas to ensure that the rights of
alleged perpetrators as well, because they also have a right. As much as victims have rights, they also have a right. And I think the accountability mechanism process, it's also very important to get into these institutions, because we've heard from the TRC how institutions were further divided, and I think the prison service was also affected by that. And you've really touched on a very important point, which I think those that are here should really take those into take note, because I think it's very important. And
to Mr. Kinte. Can you also touch a little bit on you being in the Gambia Police Force? Can you also touch a little bit on the challenges regarding the setting up of the special tribunal? Also, you could give some of the opportunities for having this. Thank you.
Thank you, Madam Chairman. Some of the challenges as alluded by the previous speakers. Among them is the impunity gap that was mentioned here. The purpose of this forum is to come up with ideas as to how to implement the recommendation made by the TRRC. We've all seen that the TRRC, from their recommendation, recommended that some of the public officials should be banned from public office. I believe a rule for one should be a rule for all. So if the TRRC recommendation bans some people, they should obviously be banned, irrespective of whatever portfolio they might hold in the office. So I think the Ictj should bear this in mind, or should try to work in consolidation with the recommendation made by the TRRC to ensure that the recommendation is fully complied with. And another challenge stated here is in respect of the resources. The resources in the nutshell are particularly the meaning might have a broader meaning, but let me just narrow it in a narrower perspective. Because every successful prosecution must have a very good investigation. Investigation is the route to a successful prosecution. And we all seen during the TRRC that the investigation are being conducted by the police or the SIS. And these investigations include obtaining statements from victims, interacting with perpetrators, and trying to discover many evidences as possible. So, but I think it is also important that a very conducive environment needs to be created for those investigators to do their work perfectly and professionally in order to make a very successful prosecution. And also to add this, that the security of these victims is very paramount, because we all know that their life might be at stake for one reason or the other. And even as well as the person conducting the investigation needs to be secured himself. Because before you secure somebody else, your life force must be secured. So it is important to redress some of these challenges alluded earlier. Also, the political will is also another challenge that we observe, and which is to what extent we have the support of the decision makers to ensure that the decisions are fully being complied. So I think it is important in order to achieve those aims and goals. Some of these challenges has to be addressed. Thank you.
Thank you very much, Mr. Kinte. I just have a follow-up question.
Yes.
You alluded about the protection for security forces. And what sort of protection do you think the security would need since you're in the force?
Yes. Protection for security forces is, we all know that the security station, I'm not saying that we are living in a state of chaos and anarchy, but the security is a bit rough. You need to be protected first. The security, what I'm talking of, that your own being, at least you should have all means to protect yourself. Because what I mean is that your life force matters before the life of the person you want to protect. So I think it is important that the security have been given with all the needs or all the mechanism accorded to them to secure themselves first. Yes.
Thank you very much, Mr. Kinte. I think we would wrap up the session, but before we wrap up, I will go back to Ms. Tal. I know you're representing NALA in this panel, so also play a key role in would it play a key role in ensuring recommendations made by the KRC and fully implemented? So since we are talking about the accountability mechanism process here, so how do you think NALA would play a key role in ensuring that this becomes a reality at the end of the day? Thank you.
Thank you. For those that are not familiar with NALA, it is the National Agency for Legal Aid, and we provide legal services, including legal representation for the less privileged, including, of course, women and children. We represent all, adults that are, adults that are that are alleged to have committed, capital offenses, and all children as well. So basically that's what we do. We are headquartered in Greater Banjul area, Kanifing. We have one office in Basse. So yeah, we represent, we go to all the courts from here to Basse. So basically that's NALA for you. And yes, Aissatou, sorry, your question.
Yes, so my question is, since you've mentioned about the role of NALA and then you provide support to
legal service.
legal service to people. So now there will be an accountability mechanism process. How would NALA be there to support this process?
Yes, like we have the public prosecution office, the state council. We also have the defense side, the public defenders. That's what we are, and that's what we do. So there will be, I think Mariama mentioned something, Mariama or another speaker. There might be, I think it was Mansour, some accused persons that do not have the means to afford the service of a lawyer, so that's where we come in as public defenders. So this accountability mechanism would be of great help to us. Basically, one, to help us be trained as NALA lawyers, because there are, crimes that we are not familiar with, we have not defended yet, such as torture and other crimes. So this will be a process that will greatly help us in those areas. So we can, like I said earlier, our services will be defense, basically defense, yes.
So you basically provide defense for victims who would need legal service, right?
Service, yes.
All right, thank you very much. I guess I'll just do a summary in local languages for the benefit of those that might not understand. Then we can go into question and answers, right? First and foremost, I'll speak Mandinka for benefit of I guess everybody here would understand Mandinka, not all, but I guess some. Darowim fola dorong napaneli sol minubiyang Miss Talbota nalale itola institution o itolle be mararing pruka je ko mol mini alon ko imang de maro soto min tata legal support la comme lawyer la karola so itol ko molle de ma kaje ko wole de maro soto min tata luwa la karola ni tate la office itol de mala le ni ta lawyer la puru lawyer la case to itol la office ka waleke baring ke mijang ate muluk jata lati ate bedo ko la prison service ate la do ko prison service ate mo communication officer la min tata diamo la karola prison la do ko la ikado ko mimbi ke prison service ate be mar la wo bundale la kaje ko moli along itol kado ko minke as prisons officers na uncle membijang Mr. Kinte ate be do ko la Gambia police le ate mo prosecutor le ni amo prosecutor ate le kaje ko aning court le kado ko ke kaje ko mol mini along ko ye tajirente yake ye londi lo wala silol karo ngani nin karo min soto pour na panel sol wolong ko na conversation o tata ñin tribunal o special tribunal o mi yalon ko tiara si le recommendation ko kaje ko minu ya tajiriyente ya kenyim bankon kan luwaya silo tamandi kaje ko yeminke mola luwaya silo tamandi ye londi silola so na ñinin kari follow na panelisol pour wolong ke ñinin ka ye mun kole ya kuwolle je min ya lon ko ñin special accountability mechanism aba sotola pour ni special accountability commencé ta mon kole ya kulle betere la je mi ya lon ko abe process o ñin nasiyan ni la so na guest follow nin ko resources be kole yala ni amoy resources wolon dépense o mi ya lon ko abe dun na ñin do ko kono kaje ko ñin do ko ke kuti mi ya lon ko a successful ta aya fole fanan ko mansakunda do bije mansakunda ka kole ya ibuka how to call political will mansakunda do bije ibuka fin ko ñin soto help me the political will okay mansakunda do bije kato political katina le kudol bije buka kino ha yalang fundi maybe nyimari kafuta nyim political party do to nyindo pat kafuta nyim political party do so aka kolyale pour ye decisional dolta akar koy be ke la party interest le jibe ibuka banko la interest jibe so ako kolya cool fanam bijele min yalon ko abe nyindo ko na sendilale Mr. Jata fana ye kolya cool fanam fole min marta prison do ko la ika kolya cool min sodoje follow ya fole ko prison condition on benyameng prison o la bungo benyameng ila bungol nata colonial days bungol long so wo bungol sul tale pour ye improve ye modernize pour ka je ko bungol ni ye fit for purpose ni amoy fit for purpose pour ka je ko mol se taranoje do ye soronne bari fanan inyanta katar la bungo kono mi ya lonko ise ni dino je bungo besenyaring ala condition no betiyaring anin fanan ako prison fanan kolya kudo bije mi yalon ko atate la domor kuodo do bije to get pour ye balance that so the domoro mi yalon ko mosa domono wo kolya kuol bebe itol bulle kaje ko itol minu be do ko la prison so ya mirale ko nying accountability mechanism min nyanda kana wo be tol de mala le fanan pour ke la capacity sol bill kaje ko itol minu prison officer ti ye karangol min yalon ko abe na falale kaje ko abe la do kuol sone yandi la le pour kaje ko minu be prison wol fanante na fa soto je inspector fanan ya fole ko kole ya kuol minu bije itol la karola minu be do ko la police wolon ke tol kanta itol solata kanta rola le janding itol be modo kantala akaya jele ko fanamu kole ya ko to kato ko nibe mo kantala fo ite fananza ite assurance to ko ite ila life fanambe protection also to ayo kole ya ko fanan anata fo ko ke fanan comme message ning misale ya fo nyame political will and I think ni mo kulete mi yalon ko molbe ka wosi dale ka fo ko political will man so to kato ko party wol be ke la party interest jibe e buka country interest jibe aning process wala interest itol mi yalon ko itol yatin na wolong wala la interest ka wala jibe so pour nga dandi water time o man soro nga fro nyimbula pour mol mi yalon ko yo question in so is a question on you and then the continue ala baraka.
All right, Baraka Bake. So we'll just take one question from the public. Yeah. You want? Okay.
Good afternoon. My question goes to Luke. Almost you've answered all the concerns that I have, but I have only two options. One, that is the rules governing Mile 2, the prisons. I left Mile 2 26 years ago. The rules there is pre-colonial. Both prisoners and detainees are treated on the same level. Because that was what I went through. And I even protested and say, I'm not a prisoner, I'm a detainee, but yet still I'm treated as a prisoner. Number two, when you get to mile 2, the first place you get to is the reception. That is where your belongings are confiscated. But the moment you get out, you can't get anything. Up till today, I can't get my properties. Thank you.
Thank you so much for that question. Now, because when you say rules, I begin to wonder what kind of rules do you want for me to explain? Because I think when you talk of rules, we have, if you look at the Prison Act, we have rules in respect to even your behavior, your conduct. And then this conduct, probably as at then, there's a lot of reforms that has undertaken since the inception of this new dispensation, where we say, because if you look at even by virtue of what we do, the minimal use of force, the opportunity given, and even the conditions there. One, it is because, as I alluded at the first instance, we said we are service providers. So the service that we are providing is service that is in conformity to the law, in conformity to the human standards. Make sure that food is adequate, not only adequate, but the food that is has that nutritious and balanced diet. The health services, it's very optimal, because now if you see a lot of capacity building has been ongoing, and even the conditions that are there, that a lot have also been improved to make sure so that even respect for the fundamental human rights and rule of law, now that we are representing people. Just as I said, application, even those prolonged cases that are ongoing there, they are no more. We make sure that everything is fast-tracked, because now we are engaged directly with the judiciary, so that we inform the CJ. So you can see even the legal representation is on the high tier, that since we have a paralegal unit, so that paralegal unit will make sure that cases are expediently made. And also, when it comes to, now you said, materials, especially the first instance, the reception that I talk of. Because one, I have been trained on asset management. Even those reception officers that you are saying, all of them are trained on asset management. And part of it is to make sure that your materials are on safe custody, because safe custody, not only human beings, and even properties. So we make sure that even if it is 10 years, I don't know, but now even if it's 10 years, we make sure that at the time that you are leaving the corridor of the prisons, your property are safely kept and even in good order, so that it is yours, it's your property. So we cannot take all those things belong to us. So thank you so much.
Thank you. All right, yeah. Thank you very much, Madam Aisha Jame. Do you want to say something else?
Just wanted to thank my panelists for the great contributions that they've given. And I think together we will be able to attain a successful accountability mechanism process. I think most of the time, one of the things that I always like to say is that the transitional justice process should be everybody's business. And I think that way we'll be able to achieve a lot. But if it's one-sided, it will be difficult for us to attain what we want to attain at the end of the day. So I would like to say this here again. Everybody should be part of the conversations and part of the process to ensure we have a successful implementation. And to victims as well, I also want to tell you to always be, be there. Don't lose hope. And I think you all are part of the process. At the end of the day, without victims, there would be no transitional justice. And I think we really need to stand fast and be part of the conversations, and the struggle continues. Thank you.
Thank you very much. Round of applause for everybody.
Thank you so much. Okay. I think all of us are seeing the screen. Can you just project, if you don't mind, IT? The team, can you just project thank you. All right, so let's just do a little bit of IT. Can everybody lift up your phones, please? And you can see a code, just go to your camera, yeah, your normal camera, nice one, and then just project it there. You're gonna scan it. That is an evaluation link that we have for you to fill. So you're just gonna use your camera and then, yes, get to the code, and then you will see your gender, your age, and blah, blah, blah. Just fill it for us, and then that'll be good. Are we there? Did you get it? All right. You see, everybody is having a knowledge of technology, right? That's it. Okay, so yes, they always say, although sometimes we don't want to end the session because it's very educative, but at this point in time, as we are filling the form, we want to invite Madam Ida Person, the Special Advisor on Transitional Justice, for closing remarks. And then after that, I always call item 16, that is lunch. All right, so after her, then I'll come back and then we'll let us know. Keep filling the form and keep scanning the code. Thank you. Yes, please.
You're welcome. Thank you very much, Amanda, and thank you to everybody. I'd like to, in these closing remarks,
ngeen ñëw pour waxtaan ak ñun ci mbiri accountability. Mbir bi nag waxtaan la. It's a conversation. We've given here a lot of information about what is going on, what are some of the challenges that we foresee, what are some of the opportunities that we foresee. And I think without a doubt, we would all agree that this is a journey. It's a journey that we have started, but my main message is that we have to see it to believe it. We have to imagine it. Once upon a time, it was almost unimaginable that we would have a truth commission. I had to go to the airport to actually see the former president leaving because I couldn't believe it. And for many people, to have that day when they were sitting at the TRC to give their stories was also unimaginable. But it happened. We had those stories, we had the TRC report, and we've had the recommendations. So although it seems like it's a very distant and long and difficult journey ahead, we have to imagine that it's possible. We have to believe that we can actually do it. So I hope that in the discussions, we leave here not only remembering that it's a long journey and it's going to be difficult legally, financially, maybe sometimes even politically, but that it is certainly possible. And what makes it possible is these continued efforts, that there is dialogue, there is opportunity for clarification from those that are leading in the process, and there's opportunity for providing feedback to improve in that process. So please do not falter in your efforts. Farluñ wara def metti na yàgg na waaye foog rek ñu def ko. Amuñ benn choice, defaluñ ko suñ boppa, suñ doomi lañ koo defal, xale yi nga xam ne judooguñ lañ koo defal. So ñu jàppalante rek, ñuy déggante, ñuy waxtaan, loolu laa bëggoon a wax, di leen jaajëfal tamit si li ngeen ñëw tey, te di leen séentu tamit si yeneen teew. Bëggoon naa ko wax si soose waaye su paasee su moolee, daal du baax. Bon jërëjëf di leen gërëm tamit on behalf of the Minister of Justice li ngeen ñëw. Ministry of Justice bi at the moment ñoo nekk di lead si nguur bi, but once we have all these mechanisms in place, prosecutor's office bi special ak independent office la dina am njiitam. Special tribunal bi, it's going to be independent amit dina am njiitam. Comme TRRC bi, the way it was independent, that's how these processes are going to be as well. But all efforts, all eyes on the Special Prosecutor's Office, because moom lañ war a njëkk a taxawal te boobu mooy door everything. So ñu ngi liggéey si loolu noonu bu baax a baax. Most grateful for your attention. I think it's time for us to eat. With that, I will hand back over to Amanda. Oh, apologies. I must, of course, as a final remark, thank Didier and the whole team, Ictj. Please let us give them a big round of applause for being true partners to the government, to the Ministry of Justice, for allowing all of us to come here together. This is one of several activities that we do together. So we're so grateful for the Ictj and for your donors as well, the Department of State, the Office of Global Criminal Justice, yes. Most grateful, Didier. Thank you so much.
Thank
you. Thank you, Madam.
A round of applause for her. And a round of applause for you yourself. Can you put your hands together for yourself? Thank you for coming, and I really appreciate it. I always say this, every good thing must surely come to an end. Abarakabake, Jerejev, Njarama, merci, and what else? I want to say thank you very much. We have to go now for lunch, and I want to say a beautiful afternoon. Thank you.
Thank you.